The date is something 93. Date was 93 2018. Social memo date it. That was in the list. The list is not social date is aslan.
Yes, contempt application.
Director is present.
Sir, namaskar. Sir, namaskar. Sir.
Yes, sir. Is appearing. Yes, sir. Director.
Sir, namaskar.
We hope that you have gone to the yesterday's order.
Yes, sir.
So, what do you say?
Below, this case relates to Constable medium irrigation project. In that project, 515 persons were to be displaced. On the own assessment of the collector Sundargarh, they claimed 4 crore 45 lakhs. And on availability, we paid 4 crore 38 lakh at the rate of 86,583 per displaced family. But I don't know why collector again for any in subsequently why they raised that the claim should be 172,845. Sir, in the
Whatever it may be, the clarification was sought for in the year 2014 and we are in 2025. 11 years have passed. So whatever you want to say, you could have replied to the letter of the collector. So that is the reason why we have asked for your personal appearance through virtual mode. So if the collector has some doubt, please clarify it. What is there? This is the simple thing, and the poor people who have lost their land are yet to get the compensation amount. It has already been deposited. Now you think that just think about the situation that it would have been disbursed in the year 2014. And how much interest they are losing if you pay in 2025 that amount. So that is also to be taken into account. So
I beg apology for this. This is a mistake. Just kindly give me 15 days time. I shall settle everything.
All right. You issue clarification what the collector wants, and we are taking up this matter after 15 days, as you say. We are fixing it on 13th of May, 2025. So in the meantime, whatever you want to do, and you please apprise us on that day that what is the development, and ask them to disburse the compensation amount, right? So these 12 persons have come. There are
339 families.
339
families.
339 families.
They are representing the 39.
So,
Milord, again, I have to tell that these 12 persons are in the list.
All right.
They are to be given the compensation also.
Also, the director R&R and ex officio additional secretary to government. This is the designation. Is it correct? What has been reflected here in the order?
Department of Water Resources.
Director R&R.
Director R&R and ex officio. What will be there?
Ex officio. What is there?
Ex officio additional secretary to government. Water Resources Department, Bhuvnesh, appears through virtual mode as per order dated 22/4/2025 and assured this court that he will reply to the letter which has been sent by the collector Sundargarh, letter number 142 dated 5/2/2014, which has been sent to collector Sundargarh, making necessary clarification. Communicate with this one, sir. And the matter may be taken up after 15 days. Of this matter on 13th of May 2015. On that day, the director shall appear through virtual mode at 10:30 and apprise this court about the development made in the meantime. All right. All right. Personal appearance dispensed with. Thank you very much. Give the name. Huh? Yeah.
Item 2.
Item 2. This is a non-registration, non-execution of the lease deed, Your Lordship, wherein the petitioner had paid the dues of the lease amount in 2019. As per OGLS Act, it has to be registered within 3 years. So there is I filed a writ petition. The court, this honorable court, said that to consider my writ application. Page 22, Your Lordship may kindly see. That is where rights.
No, you come to the order dated 31/2025.
Yes, Your Lordship.
Come to the page number 2.
Yes, sir.
Please read it out.
During the course of argument,
Yes.
learned
Please.
yes, learned counsel for the petitioner pays the letter dated so and so issued by the EDM Patnam 3 to the petitioner. It is mentioned that the time between the deposit of the rest amount and the execution of the lease deed is more than 3 years, and so there is no clear view regarding lapse of time in the execution of lease deed. In OGLS 1960, the clarification was sought for so and so, but till date issuance of order, no clarification has been obtained. Let the Northern Council of the state obtain instruction from the concerned department as to whether they have provided the clarification.
And number 2 is.
I have to take instruction whether ready.
Yes, so what is your
letter was issued, but respond has not come. Your Lordship, 7 days time.
this is the problem. An order was passed on 31/2025.
Yes, it was communicated on 1/2.
Again, it was listed on 11/2/2025.
On 1/2.
2 months have passed since the last listing, and you are not able to take up this matter next week.
Yes, sir, definitely.
The
Last
Land Council for the state.
May I say one thing, Your Lordship?
Yes.
Here, it was executed, last payment was on December 2019, Your Lordship. In February end 2020, COVID had come, Your Lordship. Honorable Supreme Court has given up.
Let them take instruction.
Yes, because it is the question of limitation, Your Lordship. 2 years has already been excused by the Honorable Supreme Court. To that end.
Land Council for the state 1 week time to obtain instruction as per the order dated 31/2025, and the Land Council for the petitioner submits that he has also received. You have also received instruction as per the said order. There is an order that you are to.
Yes, I have received as per the present value of the execution money is he is ready.
File an affidavit. He has already obtained instruction as per this, right? And you will file an affidavit of the petitioner by the next date. Put of this matter. Kebe ରଖିବା କୁହନ୍ତୁ ଗୋଟେ ସପ୍ତାହ ଆପଣ ଚାହୁଁଛନ୍ତି so let it come on 6th of May 2025.
Great.
Item 3.
Yeah, this is to come along with 31643 of 24. No, theta matters, right?
Tag.
Tag it. Next.
Item 3.
So can this is the last one.
7/4/2020. Directed them to file the. What's it possible in the report? We were asked to file the affidavit. For that purpose, I need to. Direction was given to file the affidavit. Report is there that was submitted for lordship. That is to be filed in form of affidavit. That is true.
Oh, last time when it was listed, you took adjournment.
Yes, sir.
So what about the compliance?
Let us be sure. Lordship 3 days time. Good to we continue.
The land council for the state seeks for an adjournment till next week to obtain necessary instruction. Put up this matter on 30.
Last time here, published the report.
Affidavit has to.
It is possible to our
to file an affidavit in terms of the instruction received. Put up this matter on 30th of April 2025. Yeah, along with it will come along with the review petition. 50 of 2022.
Your lordship passed the order in the review petition.
Either way,
The review petition the order.
अच्छा তাহলে এটা রিভিউ পিটিশনে করে দেবো সেইটাও লিখে দেবো উইথ কন্টেম্প পিটিশন সেটা আছে তাই না এই যে অর্ডারটা দরকার হলো এটাও রিভিউ পিটিশন দেবো হ্যাঁ নেক্সট
Item 4.
Please, Lordship. This contempt application has been filed against the willful defiance of the orders passed in this petition as well as the previous contempt application, my lords. I think the rate application has been filed to time-bound disposal of a lease case, which is pending since 2009, my lords.
No, what is the order dated 30/11/2022?
My lords, that's the order passed in writ petition, your lordship.
Okay, what was
That was in
disposed
past,
the lease case within 2 months?
lordship,
So that was passed in 30/11/2022.
lordship.
Then what order was passed in the first contempt application?
Lordship to dispose the said matter within 3 months. Further 3 months was given,
It was extended like that.
lordship.
So that was on 12/12/2023. So okay. So it yes, you take instruction. It is coming for the first time. Click on the Land Council for the this contempt petition has been filed for non-compliance of the order dated 30/11/2022 passed in WPC number 20215 of 2022 and the order dated 12/12/2023 passed in contempt petition number 9498 of 2023. The Land Council for the petitioner submits that when the petitioner approached this court in WPC number 2015 of 2022 with a prayer for expeditious disposal of lease case for 1 of 2009 pending before the opposite party number 4 Tahsildar Khurda while order dated 30/11/2022 the opposite party number was directed deal with and dispose of the lease case within 2 months from the communication of the order. In spite of the communication of the order, since within the stipulated time, the opposite party number didn't dispose of the lease case, contempt petition number 9498 of 2023 was filed, which was also disposed of on 12/12/2023, giving time for 3 months to the opposite party from the date of communication of the order to comply the order dated 30/11/2022 passed in WPC number so and so. And in spite of such orders of this court, the lease case has not yet been disposed of. Learned counsel for the state seeks 2 weeks time to obtain instruction about the status of lease case number 1 of 2009 pending before the Tahsildar Khurda, pending before the opposite party oblique contempt order. Put up this matter on 13th of May 2025.
Contempt has already been done.
By the officer in concern. If it is not done, then we'll frame the notice. We can't be lenient. The first order has already been not complied, admittedly. So you have to burst the contempt now. You give the instruction accordingly. That's what our view is.
Yes.
Item 5.
The last provision in Lordship directed Council for the State to option instruction and on dated 10/25 had order number 2 by the Supreme Court and then directing the Tahsildar to report after the death of the
When I was cheating.
Is appearing without item 5. He is appearing.
Leave it. What you have taken in?
Already instruction has been given where we are preparing the counter affidavit, we will file counter.
Lordship's previous order regarding payment of the compensation amount is
No,
assessed.
it's all right. We have asked him to obtain instruction.
Instruction already given. I have been back with the
We're listing it next week and file the counter affidavit.
May 1st.
Land Council for the state submits that he has received the instructions and the preparation of the counter is on and the matter will be taken up a week after. In the meantime, you will file the counter affidavit serving copy and the Land Council for the petitioner. This matter notice has been issued or like that order is
It is admitted by them.
Acha.
Instruction was produced at the last
Compensation is assessed but not yet paid.
2020.
issue notice कर दिया उनको 8 record submit that he has received this one. So, you should not return the question of so and so. State how many opposite parties? You are appearing for all the opposite parties as a state acts on behalf of all the opposite parties. Counter to be filed by next week. Matter to be listed on 6th of May 2025. Serving copy on the land council for the petitioner. Yes.
6th May.
Yes.
Item 6.
Right. Where the land was leased out in favor of a X of this person, a military person, and that has been resumed by the authority in exercise of the power of section Vigilance Act. But I have declared a date just
So the question which we have put, you please answer it. What is the provisions for grant of Jawan lease, and whether that can be such land which has been given on Jawan lease can be resumed?
Yes, but so far as the provision for grant of Jawan lease is concerned, that is
Lordship, these are the notifications that I have got.
Mhm.
998. Lordship, point number 4, this notification.
It is the notification.
Which I may pardon your Lordship, the copy is
One copy is
no, Lordship, 2 copies are.
that's the matter.
The
Yes.
quality of the
It's all right. Read it. You might have read it. Read it. Relevant.
point number 4. ଆଲୋଚ୍ୟ ଲିଜ୍ କ୍ଷେତ୍ରରେ କୌଣସି ଅନିୟମିତତା ଦେଖାଦେଲେ
ଏଇଟା କଣ ଜବାନ ଲିଜ୍ ର
Yes, Lordship.
ପୂର୍ବତନ ସାମରିକ କର୍ମଚାରୀଙ୍କ ତରଫରେ କଣ yes,
ଆଲୋଚ୍ୟ ଲିଜ୍ କ୍ଷେତ୍ରରେ କୌଣସି ଅନିୟମିତତା ଦେଖାଦେଲେ କିମ୍ବା ଲିଜ୍ ସର୍ତ୍ତର ଉଲ୍ଲଂଘନ ଦୃଷ୍ଟି ପାଇଲେ ତହସିଲଦାର ମାନେ ସମ୍ପୃକ୍ତ ଜମିକୁ ପୁନର୍ଦଖଲ resumption କରିପାରିବେ। ଏଭଳି ପୁନର୍ଦଖଲ ପୂର୍ବରୁ ଲିଜ୍ ତାଙ୍କର ବକ୍ତବ୍ୟ ପ୍ରଦାନ କରିବାକୁ ଅବକାଶ ଦିଆଯିବ।
opportunity of hearing.
Yes, sir.
So in this case, what has happened?
He says that it's all right, but can you proceed under OGLS Act?
Lordship,
It is here.
Yes, sir, Lordship. I'm coming to that. That in order to analyze that whether it cannot be covered under OGLS. But your Lordship, the contents of the lease agreement must be properly. It has to be analyzed in order to come to a conclusion that what are the terms and conditions of the lease.
Where is that lease deed?
That lease deed is not with us.
No, he is not having that lease deed. So if you say that there is violation for which you resume that, so you are to say that they are in that terms and condition, and how the petitioner has flouted the same, for which this resumption order was passed.
Lordship, as per the at page number, all those pertinent questions have been discussed, your Lordship, at page number 49, 48, Lordship. 48, 40. This at page number 47, Your Lordship.
47 it starts. Yes. Violation of term. Read it out.
Yes. Violation of terms and conditions in not doing any kind of cultivation, agriculture activities on the leased land since the time and use. Written reply of Sri Dwivedi has been analyzed here, Your Lordship. I will read it, Your Lordship.
Yes, yes.
At the outset, I disown the above allegation abruptly. It is admitted fact that the land measuring of 4 acre decimal has been leased out in my favor, bearing plot number so and so in village Basantpur. Though the lease case number 204 of 2003 under the scheme of lease of government land to ex-servicemen in consonance with the government circular number so and so dated 1998. Lordship, this is the notification of 1998. The lease is a special grant to an ex-serviceman, and after observing of the necessary formalities like issue of general proclamation causing inquiry of eligibility and other ingredients of Tahsildar, Baripada granted the lease of government land measuring so and so. And that after the confirmation of the order of the settlement of land, Potta was prepared in my name, imposing only one condition, that the settlement of the land cannot be transferred within a period of 10 years without permission of the authority. Lordship, that photocopy has been provided here. Then that after grant of Potta in the year 2005 and after taking over the possession of the leased land, I started to cultivate vegetable. From 2005 to 2018, he has cultivated the land as per his claim, Lordship, for 14 years undisturbed. And then he states that due to his health problem, that is cardiac disorder, he has stopped cultivation, and then he has stopped cultivating the land. Lordship, our comments may be seen here. This reply is totally indifferent with facts in the field visit memorandum report as well as fact existing in reality. Mr. Dwivedi himself was present on the day of field visit to the household to the leasehold property on 21/12/21, along with Tahsildar Baripada, Revenue Supervisor Baripada, and RI Buddhi Kamri. He himself admitted that the land is lying vacant since the time of lease. To affirm this, he has also put his signature on the field visit memorandum, admitting fact the land is not cultivated since last 15 years in presence of all the above said officials. So the claim of cultivation from the year 2005 to 18 is false one and against the earlier admission of facts on 21/12/21. Hence the written reply is not valid against the findings made during the field visit to the said leased property. Subsequently, point number 2, Lordship, it has again been analyzed. Neither the lessee nor the family member is a practicing farmer on the land. Can I read it? The show cause submitted under allegation number 1 will make good the reply against the allegation under item number 2. It is to reiterate that the land was under cultivation activates from 2005 to 18 for about 14 years, and due to my health problem, the same has been discontinued. At present, I am under treatment and the cultivation activities will again started shortly with after my recovery. I, under the above circumstance, disown the allegation leveled under item number 2. Lordship, our comments that has been put up. The scheduled leasehold property is located at Basantpur Moja, about meters away from the residence of Sri Dwivedi, and the same is lying vacant. The land lying vacant since a longer period of time is also established from the local inquiry conducted by RI Buddhi Kamri in this regard. Neither lessor nor any family members of the lessor is a cultivator practicing farmer on said scheduled leasehold property.
If we come to the ultimately the conclusion part, that is in page number
52.
51, 50 reason. Before delivering
into the matter, the relevant guidelines, instructions of the government that has been issued from time to time on stated matter is examined as follows. That government order wide revenue department letter number so and so dated 16/4/1998. Lordship, this is the paper that I've handed over. That is the notification 1998. Prescribe details of clause in which the land or cash issued to ex-military personnel. This letter also empowers for resumption of leased out land in case of observation of irregularities on leased out land to the ex-military personnel. In addition to the above points, it is also mentioned that the government-wide revenue and disaster management department letter number so and so dated 28/4/2017 has issued instructions for resumption of leased out government land which are remaining unutilized for more than 3 years from the date of settlement. Point number 3. Further, government wide revenue and disaster management department bearing letter number so and so dated 27/9/2013 has prohibited conversion, Lordship, it's conversion, strongly treated, conversion of agricultural land under section 8 capital A of OLR Act 1960 leased out to defense personnel under Government Act 1895. It's Government Grants Act. Further, it is also intimated that government wide gazette number so and so dated 10/3/2014 has issued instruction to pay cash to ex-servicemen, or non-gallantry award winner, defense personnel instead of leased land, keeping in view of scarcity and preciousness of land. On view of the above discussions, it is clear that irregularities has been observed of the above leasehold property. In view of above findings, the undersigned is inclined for resumption of said leasehold property. Hence, record keeper of this office is directed to resumption the following land schedule to government Rakhita Khata.
Yes, so what do you say?
Your Honor, accordingly, the case record is submitted to the collector and district magistrate through, in a lordship may turn to next page. The order of the sub-collector while approving the resumption, last but one paragraph. The provision of law under Government Revenue and Disaster Management Department under clause B of section 3B of the OGLS Act 1962 as submitted by the OGLS Amended Act 1913, such by letter number such and such and letter number such and such. The land settled up to the end of March 2014 for the purpose of homestead person and landless illegal laborer is liable to resumption if such land is lying vacant for. So, while approving the order of the Tahsildar, the sub-collector has never applied the mind to whom the land has been leased out and how it has been resumed. First of all, thereafter it was sent to the collector, and the collector just simple put the seal saying that whatever observation given by the sub-collector and the Tahsildar is correct. So far, my lord, so far the findings of the Tahsildar is concerned, also the so-called this I submitted my reply. In my reply, I specifically mentioned the lordship may turn to first the so-called notice. The so-called notice is at page 34. Lordship got page 34.
When the final order was passed by the collector.
Was passed by the collector, I challenge it in the appeal. Pursuant to the direction passed by the Supreme Court in the repeat. RTC has confirmed the same.
Where is that order?
At page 59.
Same provision has been quoted, that OGLS Act.
OGLS, same provision has been quoted. Apart from that, if my lord, it was never a condition, it is never the, while resuming the land, they have not dealt to it. If I am not using the land for the agriculture purpose, then what purpose it is being used? That is the mandatory requirement. That is the certain provision of law.
You not used at all.
You said that they said that it has not been. That is on the basis of your statement, and you have signed on that memorandum. Perhaps they when they visited that
21st.
No, they say, my lord, they issued the so-called notice. I supplied I submitted my reply. If my lord, they will not supply my reply and they will not accept my reply and they will dispute the fact.
So I have been given, I should have been given an opportunity to prove it by way of evidence, by adducing evidence. That has not been given. Only at that your lordship may visualize when the resumption proceeding started. Resumption proceeding started when I applied, and rightly or wrongly made an application. As per the terms of the lease, after 10 years he has the right to sell. But after 14 years he made an application that I want to sell the land due to my ill health. So after that was not considered. I arranged a buyer. So I submitted the sell deed. That was not found that it is government land. I approached this honorable court. This honorable court directed the sub-registrar to consider and accept the sell deed. Thereafter, the resumption proceeding was started. Not before that.
Lordship, may kindly
Only because I wanted to sell the land that has been.
Lordship, may kindly have a glance at page 43, Lordship. During field visit by the Tahsildar Paripada to the above land schedule, following observations were found which can be termed as irregularities in the said leasehold property. 1. That Sri Dwivedi is not doing any kind of cultivation, agriculture activities on the said land since the time of lease. 2. Neither Sri Dwivedi nor his family members are practicing farmer on the above said land. 3. Sri Dwivedi have made 20 feet wide road on the southern side of the land and 10 feet road on the western side of the land schedule.
And so far as the road is concerned, my lord, it is a specific case that prior to lease, that was the government road.
What are the citations you are placing?
Yes, sir. (1990).
That is also a Jawan lease case.
Yes, yes, the Jawan lease case.
Yeah.
Yes.
Which paragraph?
Paragraph 7 and also. 1994 two-wheeler, page 149. Rajkishore purchase ratio.
Yes, please place it. Paragraph 7.
My lord, paragraph 7. Lord, counsel for the petition has relied upon the government of Orissa Home Department resolution number such and such, which declared the facility to be given to the Jawan of Orissa who proceeded to forward areas. This was decided in consideration of grief and sacrifice of officers and men who are proceeding to forward areas in the active service. The categories of person and the men who would be entitled to such facilities have been enumerated therein. It is not disputed that the petitioner is one of the eligible person to the facilities declared under the aforesaid resolution. One of the concession available to the eligible person under this resolution is that such person on return from service will get 5 acres of land free and make ready for cultivation.
No,
at
this
government.
point particularly, suppose this is it has been granted under the
Government Grants Act.
so it cannot be that OGLS Act is not applicable. That is the legal point.
Yes, that is the
which
point.
which stated.
That is towards the last of that paragraph.
Yeah.
In the aforesaid
The last phase.
6 in the
That
aforesaid
the suo moto
Yes,
proceeding
in the
under
aforesaid
section
premises,
732
the
of the
conclusion
Act
is
would not be
irresistible that
resorted to.
the settlement of 5 acres of land in favor of
otherwise.
what it was under the lease principle read with government notification which made special provision for special category of person who could not be treated on the same footing as private individuals. It is therefore followed that so much proceeding under section 7A(3) of the Act could not be resorted to for examining the correctness or otherwise of the settlement made in favor of the petitioner. The so much proceeding initiated against
Any contrary decision you have found?
Lordship,
my lord, another decision, my lord.
Yeah.
Following this, The last page of the song. 2000.
rely କରିକିନି order ଟା pass ହେଇଛି।
In the similar matter came up for consideration before this court in S.K.Sahoo Hon'Ble Orissa, wherein ex-army personnel challenged the order.
Was this in your case 7-3 proceeding was initiated?
Yes, sir.
7-3.
Yes, sir.
So was the 7-3 where 7-3 was invoked.
Notice was issued
Under which provision? Is it what?
It,
In your case,
not to get at,
is it a case of 7-3?
yes, 290 page 293, last paragraph.
That which in the judgment. From here you show us that in this case also the proceeding was under 7-3, section 7-3.
No, here, my lord, in the notice they have not stated any provision of law.
Yeah.
But while approving the same and confirming the same, and while also confirming the appeal, they have resorted to section 3.
Section 3.
Now the
Yes.
first order which was passed, that was by Tahsildar.
Tahsildar.
Which order that is?
That is, you'll have to get that. Annexure 8.
Annexure 8.
Yes. The relevant portion, my lord, page.
Annexure 8 ରେ କେତେ ଗୁଡାକ order ଅଛି? କୋଉ order ଟା?
That is page 50 and 51. That my lord read out those.
Read out there. That has been
Thereafter, your lordship turn to page 52.
52.
This Tahsildar referred it to the sub-collector, to the collector, through the sub-collector, and while referring the matter.
Tahsildar order ଟା ଦେଖାନ୍ତୁ। ଏଇଟା ତ ଯୋଉଟା conclusion ଅଛି 51 ରେ।
51.
There in this order, nothing has been mentioned about OGLS Act.
No, there this Tahsildar has not mentioned. But while passing the final order, the collector has exercised the power on.
If you come to page 59, at the beginning paragraph, it is written that the appellant has filed this appeal under 7(1)(c) of OGLS. But you show us that this is a proceeding emanating from a 7(a)(3) proceeding. Is it a proceeding emanating from 7(A)(3) proceeding?
Clause B of section 3B of OGLS Act. Your lordship may turn to page 53. It will be clear.
53.
Page 53, the order passed by the collector. The collector resumed the lease matter. On the proposal of the Tahsildar, the collector has passed the order. May I place that order, my lord? Page 53, last paragraph. It is a provision of law under the Government Revenue and Disaster Management Department under clause B of section 3B of OGLS Act 1962 as substituted by OGLS Amendment Act 2013 issued under letter number such and such and letter number such and such that any government land settled up to the end of March 2014 except the settlement made in favor of homesteadless person and landless person laborer is liable to be resumption if such land is lying vacant for more than 3 years and used other than agriculture purpose. So the order passed by the collector, that order was challenged under section 7C because this honorable court directed to prefer the appeal. In the earlier writ application, I had approached this honorable court challenging the resumption order instead of preferring the appeal because that the order was out of jurisdiction, without jurisdiction. That is the.
In pursuance of the order dated 21/4/2025, the Learned Council for the state has produced
Then 498.
এটা Quebec এটা
10,498.
16,498.
16 or 10?
What should be 16?
16.
এটা অর্ডারটা তো অর্ডার dated 10/4/1998 passed by এটা কি পাস করছেন
16,4, sir.
16/4 16/4/1998 passed by the government পর্যন্ত এটা রেভিনিউ ডিপার্টমেন্ট ঠিক তো
Yes, sir.
ইংলিশটা নাই কি আপনার
Lordship, at page 50,
লেখা আছে না?
50
at page 50,
তো
below the comments, point number 1.
50
page 50. Oh. So first one. Read it. The reference.
16/4/98 लिखी जाए the Learned Council for the state produced the government order by revenue department letter number JE bracket JL S-62-19513 dated 16/4/1998 the page number 50 रही है ना wherein it is mentioned about the procedure for resumption of a land which has been given on lease or which has been leased out to ex-military personnel. The order is taken on record. Stop. Learned Counsel for the petitioner emphatically contended that since the lease in favor of the petitioner has been granted as an ex-defense personnel under the provisions of Government Grants Act 1985, the cancellation of such lease adhering to the provisions of OGLS Act 1962 is not permissible, particularly when the Jawan lease is completely different from the lease granted under the OGLS Act. It is further argued that the Tahsildar has no jurisdiction or authority to resume the lease granted in favor of the ex-defense personnel exercising the power under the provisions of OGLS Act and the impugned order of the collector dated 29/4/2022 would clearly indicate that the provisions of the OGLS Act has been resorted to while resuming the land to government khata, and even the Revenue Divisional Commissioner Central Division Cutter has also invokes its power of appeal under section 7(1) bracket small c of the OGLS Act 1962 while deciding the OGLS appeal number 2 of 2022 filed by the petitioner challenging the order dated 3/6/2022 of the collector and district magistrate Moyganj in lease case number 204 of 2003. In support of his contention, Learned Counsel for the petitioner placed reliance in the case of Rajkishore Das versus State of Orissa, reported in 1994, bracket 2, Orissa Law Reviews 149. So also, Mirza Sadiq versus State of Orissa and others, reported in 2010, Supplemental 2, OLR 292. The Land Council for the petitioner has filed the date chart, written note of submission, and citations which are taken on record. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice on behalf of all the opposite parties. Extra copies of the writ petition be served on the Land Council for the state during course of this week. Matter to be listed after 4 weeks. Counter affidavit, if any, be filed in the meantime. IN number 1020 of 2025. Till next date, the petitioner shall not be evicted from the land in question. Yes.
Item 7.
May I discuss the land in the house of the petitioner which acquired by the NS authority for extension of to 20 miles. There is your losses on the last petition. Whether the petitioner is approached under section 3G of the act or not. In fact, they have not individually approached, but they have filed a representation under section 3.
No, you have to file the appropriate application. The provision is there that you have to file
individual application.
Like we are disposing of this, no? Petitioner Shumant Kumar Mohanto has filed this writ petition, praying for a direction to the opposite parties to evaluate the acquired land and house situated over Khata number 23, plot number 782 under Mauja, Anabeni in the district of Keonjhar. Before demolition of the same, and to give actual compensation with proper valuation of the said land and house to the petitioner. It is the case of the petitioner that the land was acquired for extension of NS number 220, NH road number 220, and the assessment value for compensation of the cost of building, trees and wells were very low, and the measurement of the land and buildings were also not done properly, and the house of the petitioner was valued at rupees 9,52,119 by the authority. The Land Council further submits that the petitioner approached the collector by filing a representation for enhancement of the compensation amount, but no fruitful result has come out. On the last date, that is on 17/4/2025, when the matter was taken up we ask the Land Council for the petitioner to examine the relevant provisions of National Highways Act 1956, which permits the petitioner to file an application before the collector, who is the arbitrator under Section 3G5 of the National Highways Act 1956, for redressal of his grievance of claim of higher compensation. The Land Council for the petitioner fairly submits that the petitioner can invoke such provision, and therefore he may be permitted to withdraw the writ petition to approach the appropriate authority in accordance with law. Accordingly, the writ petition is permitted to be withdrawn, giving liberty to the petitioner as such. Yes.
To trying to demolish the house, issue notice for to vacate the house. No course of action.
No question. You approach the proper authority. You have been paid the compensation amount, but you are dissatisfied. Petition made. The compensation which was quantified has been paid, but the petitioner is dissatisfied with the valuation.
On 4/12/24, they have issued notice to vacate the house.
It's all right.
They will compensate.
You have been paid compensation. Now you say that this would be the value. So that is the arbitrator is to decide, and in case you are aggrieved, the appeal provision is there before the district judge under Section 34 of the Arbitration and Conciliation Act. Yes, next.
Item 8.
Challenging the order passed by the collector and district magistrate Jagat Singh Purvari, he has passed the order that the award it has been passed against the person that is illegal, but still then he has not passed any order so far as payment of compensation to the petitioner is concerned. The facts of the case are like this, my lord. Annexure 1, the acquisition has been made. For the purpose of acquisition, the Annexure 1 page 10 is the notification for acquisition. And the petitioner land under Annexure 2 has been acquired. Thereafter, the notice has been issued for hearing and other things. And there, since the compensation has not been paid, I have approached this honorable court, and this honorable court directed me to file face representation before the collector. And the order is at page 5 of my writ application.
Page
5 of my writ application. That previous writ application, the order, this honorable court directed me to approach the collector, district magistrate, for redressal of my grievances.
So what happened?
Thereafter, the Annexure 5, Lordship. Kindly Annexure 5 page.
Annexure 5, there are a number of orders.
I mean, page 23, Lordship, concluding part.
No, the order starts at page 21.
21, Your Lordship.
5/12/2024 orders.
Yes, Your Lordship. That is on the chart.
Okay. So ultimately, what has been held in view of the discussion?
Yes, ma'am.
Yes.
In view of the discussion made above, I find compensation amount received by Vijay Kumar Mahanti and Radhanath Kara is completely illegal and not permissible under any provision of law, as it is fit case which I direct the Special Land Action MIP Jagat Singh to take proper step to recover the compensation amount along with the interest thereon under the OPDR Act and file FIR against Vijay Kumar Mahanti and Radhanath.
Who are that Vijay Kumar Mahanti?
Somebody else, I don't.
Lordship is above para in view of same page. The sale deed was executed by the petitioner in favor of one Vijay Kumar Mohanty and Radhanath Kara. Then in this petition, while deciding the reputation, collector has set aside the sale deed without reviving it and paid that illegally paid. Once he executed, the sale deed has been executed, right or wrong?
Sale deed executed by
petitioner.
So
no permission was obtained. Therefore, then another provision is there, disputed question of fact. How the court, this honorable court will sit as a executing court of the order of the collector.
So, what action thereafter taken by the?
In view of the narration of the fact stated of the registered sale deed such and such in favor of Vijay Mohanty Radhanath ipso facto invalid. How can this miscase be?
This order was passed without even hearing those two persons. In whose favor you executed the sale deed.
Yes. That sale deed has already been cancelled by the sub-collector.
There is no
yes, that R1 itself says you'll also annex 2, page 11.
What is the document?
Yes, what the certificate?
There is no observation in
No,
this, or they are
whether in such a case, whether it was not necessary to implead those two persons as opposite party. The order has been passed against them, and the order was passed to recover the amount which they have received as compensation for the land which they have purchased from you. Even if you say that that has been that sale deed has been
already been set aside by the appellate
But
court.
the compensation meant for you has been taken by them
Yes.
because of the sale deed which you have executed.
so.
So then they are necessary party. That's what.
Prior to that, Your Lordship, that prior to that notice has been issued by the collector, the special land action.
The order is here before us in page number 21. We are just reading that who are the parties. The party is Dhrubacharana, that means you, and there are three opposite parties.
Yes.
The first one is special land acquisition officer, second is collector and district magistrate, third is Tahsildar Young. The two persons against whom the order has been passed that you recover the compensation from them, they have not been made party in this.
See, for the same land, the government will not pay twice the compensation. The compensation has been paid to these two people. These two people are who are these people? You say I don't know, but it is you who has sold the property.
They are residing somewhere else. The notice has been
But
issued.
you sold it.
Issued notice has been issued.
You have created.
The case is put up to the Lada GPH legend. The G Chaudhary Lada Council for the petitioner is present. Notice issued through registered post to Bhendi Vijay Kumar Mahant and Radha Tara.
even though they have noticed, they have not, did not turn up. But this Honorable Court, how can we direct them to execute the order? There is a provision of certificate of proceedings is there.
No, just a minute. You are saying that notice has been issued. Whether the notice has been made sufficient, then how can you finally decide the case against them? The very first paragraph, it itself indicates that the notice issued so and so are returned back without service. And the order has been passed
Directly inquiry,
FIR, all these things against them. They should have given an opportunity of hearing. And now you want that the High Court should execute this order. High Court should pass the order that
let the collector decide in their presence. Subsequent modes are available to the collector. They can eat the notice are not subject.
If they are not made parties.
But in fact, from the order sheet, it is mentioned that the notices are.
Manu पठेइदे ना आपण प्रेयर करथिबे कि कोन गोटे हेइथिबो बेली रजिस्टर्ड पोस्ट रे नोटिस जाईची आपणकर भेंडी मानकू यू आर द वेंडर एंड लेखाइजी मध्य रजिस्टर्ड पोस्ट टू द भेंडीज तो नोटिस कोन पई गला देयर मस्ट बी सम अदर ऑर्डर प्रायर टू दैट
order sheet text from the two instructions I have been got. And exercise the entire order sheet I have been. Starting from page 16, that in view of the direction of the Honorable Court, the miscase was registered. That at page 16.
There in that writ petition, they were made a party or not? They were made party in the writ petition. When matter was reminded, they would have been also given notice properly. In their absence,
that.
Now it is up to you to pursue the matter before the special land acquisition officer. We cannot entertain this writ petition. This is not the executing court. And moreover, when we found that the persons have not been given opportunity of hearing before the appropriate authority, they are not made party.
When the sale deed was cancelled, date? Date.
Yes, number.
Tell the date.
Well, the order of cancellation of the sale deed.
nothing observed in the order.
Tell the date. We have the date.
No, nothing mentioned. Either the before the collector will
Before or after that we want
nothing.
Before or after, when it was cancelled?
Prior to that,
tell the date. Because the money was disbursed to them on 25/3/2011. When the sale has taken place and when it was cancelled. You tell those two dates.
Sale was executed in 1995.
95. When it is cancelled?
99.
When it is cancelled? They are not the stranger. You only sold them.
In the date chart which you have given, all such details have not been furnished. Just 5 dates have been given. You have posed as if they were stranger. You have not even mentioned that one sale deed was executed, then it was cancelled on what date, when the compensation amount was disbursed. All these are necessary to be reflected in the date chart. Then why such a date chart has been given? If all the details are not furnished, what is the purpose of filing this type of date chart?
It could be construed as a concealment. First of all, you made a statement that they are stranger, we don't know.
No.
First statement you made.
Sell it.
Whereas you only sold them the property. And they have taken the compensation.
That has been revoked, my lord.
Give us the date. Whether the date when the compensation was paid, on that day the sale deed was in existence or not. If the sale deed was in existence, they have rightly taken.
That is true.
Where they were the owners.
Prior to that, it has been cancelled, my lord. I'll promise, my lord.
There is no bidding. In the petition is also no bidding is not there. It is cancelled.
We will not entertain this writ petition. Why will go and
Charge may be given so that I can file this.
No. Better course would be
you
withdraw it. Otherwise, we have to pass some order.
Some order will pass. It will go against you.
Better you withdraw and do it.
All these things we will note it down. That opportunity has not been given. Notice is not sufficient. Order has been passed against them. So this is
let the collector, my lord, after
if
notice,
you want, just withdraw.
Otherwise,
we'll pass all these orders, and it may create problem for you. So the land counsel for the petitioner seeks permission to withdraw the writ petition accordingly disposed of as withdrawn. Yes.
Item 9.
Lordship, may I permitted to address my lords on virtual lordship?
Yes.
The matter last date, lordship directed me to submit the land record, lordship. The ROR printout from the official website of the Tahsildar Tangi, I have submitted this before the registry of the Honorable Court. Perhaps that memo has not been in the attached. My friend Mr. Palle is there to hand over the document, lordship, this ROR printout from the official website of the Tahsildar Tangi.
In respect of some lands which is stated to
Prayer
for the irrigation project and canal construction in the district, even though the plot number and khata number has been mentioned in the representation under Annexure 1, but no documentary proof has been filed in the petition to show that the petitioner is the owner of the aforesaid land. The representation of the annexure is someday.
Lordship, one annexure.
Prayer make a class. The nature of prayer is
to dispose of my representation, lordship.
Direct the grant, maybe further place to directly raise the height of Randa Dam.
Randa Dam, lordship. This is the overall demand of the farmers of that locality. It is only the chief engineer minor irrigation project can a decision on this issue, lordship.
Line that may be relevant. Compensation, appreciation. This is totally different.
Lordship, my prayer is that simply they have to be disposed of my representation. That is my whole prayer.
Let him approach the competent authority, government also if they are.
Yes, lordship. Yes, I will approach your lordship and simply direct to that. My representation to me kindly be disposed of by the.
Unless we see that you are the owner of these lands, how can we say that you have mentioned number of lands and claiming compensation for the acquisition of these lands? So unless we are satisfied that you are the owner of these lands, which has been acquired by the government, so where is these documents?
Lordship, my friend Mr. Palle is present in the court of the Honorable Court. I do not know. One copy also have filed.
It hoji kon kahana re eta apon petitioner ki
Goli dei.
Goli dei, lordship.
Goli dei. Lordship. Goli dei na re goli dei swami auri guda lokong na achi.
Lordship, it is a family property, lordship.
Of the plot number kete lekchanti apon representation ne.
Lordship, my representation plot number khata number 47/57.
please.
47 by 60, plot number 130,
plot number
130 by
just go a minute one.
130.
Plot number hochi 130 130 by sky choda.
Lordship. It is there in
Wait a minute. 130
Hatyana Kramika number 47 by 60.
130 by 70 etc.
5 plots.
Plot number 125. 125 kahin?
Lordship, that is in khata number, different khata number.
Eight ଅଛି.
Lordship.
Khata number ଏଇଟା ହଉଛି
47 by 57.
57.
Lordship.
Till date, no land acquisition compensation has been paid. So, where is the documentary proof except your representation that
Lordship.
this land has been utilized for that canal work?
Lordship, I don't have any other proof. If your Lordship direct me to produce the visual of that land where the canal work is
That's
going
all
on.
right. We find that the land which has been mentioned in the representation, those lands, these RORs are refers to those plots etc. Plot खाता number एटा ठीक अछि जे ए जो land गुडा को acquire करिसेंती हिची बेली अभरमेंट काई आपन करो
Lordship, acquire ସେମାନେ କିଛି କରି ନାହାନ୍ତି, କିଛି ପ୍ରକାର କୌଣସି ପ୍ରକାର ଫାର୍ମର କୁ ସେ ମାନେ କନଫିଡେନ୍ସ କୁ ନେଇ ନାହାନ୍ତି. Not only to this petition.
acquisition केमती हला आपन compensation कोन काई देबे?
That's what they say. Till date, no land acquisition process has been initiated, no compensation is granted. The 100 trees were cut.
Para 5 what it reveals.
And for cutting of 100 trees and all that, due permission is required from forest department. They might have taken.
Lordship, they have not taken it.
If they have not taken, the law will take its own course.
Lordship, that is why your Lordship may issue the notice. Lordship,
channel on the land of the petitioner. Concrete channel cannot. Concrete channel, the lining work is permissible because of the scouring of the embankment and to free flow of water. Let it the whole dispute, let it approve the appropriate government if it's
This type of it would be a headache once you direct the authorities to dispose of this representation. Then tomorrow you will come for a contempt petition. That
Lordship, your Lordship may issue notice. Let them say in their counter what they have done. Lordship.
Question of the you withdraw
See, if
this
a cause apex and arose in your favor, then and a right is bestowed, then a writ is maintainable. What right do you have? You tell me.
Lordship, I am the recorded tenant of the land.
No, for
and they are influencing my land.
No,
Lordship,
do you have a right? Do you have a right that a writ, your representation has to be considered?
Lordship, my prayer.
Do you have a right to enforce under a writ petition?
Lordship, I do not know anything about this. Why they are doing the construction on the
writ petitions are being filed to enforce the right. Where is the right? You tell me.
Lordship, my another prayer in the prayer is that Lordship, this is a irrigation project under the Noyagad district. Lordship, this Ronda dam under the mine. Lordship, bear with me for 1 minute. Lordship. I pray, Lordship, bear with me for 1 minute.
Division to irrigation are something different. Irrigation division of also Katak, Jagatsinghpur amalgamated. Division something other that cannot be. That are Noyagad.
Superintendent engineer Noyagad is doing this canal work under the land belonging to the collectorate Khordha jurisdiction. Lordship, it is under Khordha land. Tahsildar Tangi is under Khordha district. No compensation, nothing there high-handedly. Now let's say they are doing this work, activities. Lordship. And poor farmers, they are nothing, they cannot go anywhere. Lordship, without approaching this honorable court. Lordship. That is why I request, let the representation, what is pending before them, let them consider. Either they may refuse or they may ascertain, yes, we are the things, acquired your land and we will do the things.
So, see the beginning of your writ petition is applications for a direction to the opposite party to pay compensation. You yourself say that there is no acquisition. There is no question of compensation. In your representation, you say that there is no acquisition. If the land is not acquired, there is a question of compensation to be paid to you.
Lordship, I am not able to hear your Lordship because of the lack of proper. There is some problem in the system, Lordship. I will present before your Lordship on 30th. Can your Lordship call this matter on 30th? I am not able to hear it.
Grand Council for the petition as rights to R1. And then you are saying of this petition has been filed by the petitioner.
Lordship, the audio part of my system is not working, perhaps, Lordship. I'm sorry.
The writ petition has been filed by the petitioner, Boli Dei, with a prayer for a direction to the opposite parties number 1 to 3. For grant of compensation before doing any concrete construction and to acquire the land with a further prayer for a direction to raise the height of Rondo Dam so that more area can be irrigated, and for the direction to initiate legal action for uprooting the trees on the land of the petitioner, and for a direction for compensatory afforestation. The land counsel for the petitioner mainly praised for disposal of the representation dated 10 to 2025, which has been submitted before the chief engineer, minor irrigation project, heads of department building, and in that representation, it is mentioned that till date, no land acquisition process has been initiated, no compensation has been granted, and therefore, the before initiation of canal work and acquisition of the land, farmers oblique be consulted and steps be taken for illegal falling of trees. And further, it is mentioned to raise the height of the dam under Mundla Moza so that more area can be irrigated and every farmers will get water to their land and oblige. The entire writ petition, so also the representation is a bundle of confusion. Therefore, we are not inclined to entertain this writ petition. Stands dismissed. Next.
Item 10.
Rejection of similar internal communication.
Lordship, may I permitted to withdraw, Lordship, to approach the competent authorities, Lordship? I permitted to withdraw.
No permission is necessary. Go
The dismissal will cause me a lot of
Item number. So what order has been passed here?
Lordship, item
ସେ ଯୋଉ order ହେଇଥିଲା,
the authority, Lordship.
that order is not applicable because annexure 5 mechanism class.
Annexure?
5. ସେମାନେ କହିବା 28 rejection ପରେ government has passed the order. That's why there is an exception. This one also was set aside because 28 was rejection. So annexure 5 ଟା do not communication between
আমি তো কইছিল না অর্ডারটা আনিও কোন
সেটা আরতে ଗୋଟେ order টা দেই দেন সেই order ହେଇলি
In another case, we have asked you to file that order. I think yesterday.
Yes, I have been directed to produce the order passed by the Lord civil judge.
Yes, yes. Where is that order?
Order টা দেইনো সেটা next week আছে. Next week দেই দেব.
দেখুন the land council for the petitioner 6 adjournment till next week. To produce the certified copy of the order dated what is the order?
Yes. Order dated
10 to
2023.
Judgment and order dated in 10 to 2023 passed by the London Senior Civil Judge Nuapada in LAR case number 183 of 2010.
Yes.
Asanda sapta rakhna na?
Yes, yes.
Next week. Yeah. Sure. They're just coming.
Item 11.
May I please? I'm at the interim stage. My interim prayer was refused by the London Tribunal. That is how I'm before you, Lordships. To appreciate the fact, my lord, a small one-page note sheet I have given. I have kindly perused that. Thereafter, I'll show the documents to you, Lordship.
This is what happened on 17/4. Mr. Pari,
Yes, this we have filed the counter affidavit.
you have already filed.
Yes, already filed.
Okay.
My lord, what I am suggesting, they are
Ah.
coming against the interim order, then it is as regard the maintenance, but the question is a question.
Ah.
But they file a IA annexing a document representing the state of Odisha. I have gone through it. There is a IA is there. There is
If the counter affidavit has been filed, so the
Yes.
main original application is to be disposed of what is there. So
Yes.
Have you received the copy of the
Yes, I have received the copy of the
Do you
Union of
intend
India.
to file any rejoinder to that?
Yes, yes. No, they have not filed here.
Before the
Tribunal.
Central Administrative Tribunal,
Yes,
the OA is sub judice.
yes,
Ah,
yes,
they have already filed a counter affidavit.
yes,
Copy must have been served on you.
yes,
We are asking you a question that whether rejoinder affidavit you intend to file,
yes, I will file.
you will file.
Yes. And
How much time?
State has also not filed the counter, taken time.
So, no, if the state so like, they can file it or not. So, what is that OA number? OA?
OA 67, my lord.
No, have you annexed that OA?
Yes, yes. My lord, the Lordship kindly peruse.
Copy of the original.
Page 72 begins. Annex 13.
72.
But prayer is at page 85.
What is the impugned order?
My impugned order is 6/12/2024.
What is that order?
That is that notification at page 47. Annex 3. Kindly mark this word. Sir, I am directed to refer to the subject cited above and to convey the approval of the competent authority for appointment of Sri So as Deputy Inspector General in Central Reserve Police. Now, today, on the date of relieving and date of deputation, I was holding the post of IG, Inspector General of Communication in the state cadre. Now, I was deputed to a lower rank, that is DIG. I am working at level 14 in the pay matrix, and I was deputed to the post of 13 in the pay matrix. But now, kindly see the next page, kindly see page 48. This notification was never communicated to me on that date. On 6th of December, it was not communicated. Now, next page, kindly see. Next page, page 48. See, impugned notification, the IG rank will be deputed, appointed on deputation to DIG. Page 48, I have signed as IG of Police Communications on 11th. And first paragraph, last line, as such, I am not inclined to join this assignment center. And deputation law or that ELOship note, it has to be 3 party. Consent of the employee, consent of the state, or the consent of the center. Now, I have not given consent because it is lower in rank, it amounts to reversal. And somebody.
IG of Police, the services of one page, Annexure 5 is very clear. At present, IG of Police Communication.
Last line is released.
DIG.
Gotte rank gotte pay matrix and last line he is relieved.
Sometimes on deputation, once somebody goes one rank higher, they go.
One rank, no, at the same level. At the same level. I have applied for
CBI, when they go to CBI, one rank higher.
Yes, yes.
CBI.
The CBI practice in CBI, yes.
One rank higher this.
Yes, deep blue
Yes,
blacksmith.
Lordship is correct. Yes, yes.
Even if he is a sub-inspector, he can be appointed as the inspector.
He can. He will
Just
go.
a minute.
That is
Yes, just
CBI.
what. That's why I am proposing, my lord, it is subject to acceptance of my lord. He has filed a representation to the government of Odisha. That is annexure I by A in the IA number 6132. The state can consider and pass necessary order.
Yes.
If they are not ready to relieve,
7 days they may pass the order because state government has not given consent, and I have given consent.
18
So two consents are not there, and you should know the concept DPU adverse judgment. Consent has to deputation has to be tripartite. Without that, they can. That was also affirmed in 2022 by Honorable Justice D.O. Chandrachud.
If they are coming with a representation to the court and they are saying that it is pending before the additional chief secretary, Home Department, Secretary Bhubaneswar, then let them consider without infringing any order of the
No.
Let them decide. Ultimately, the tribunal will dispose with them.
There is no such prayer in this writ petition. The writ
Yes, only they are coming for
a particular purpose.
Yes,
set aside the interim order dated 5/3/2025. That was interim prayer was refused.
Refused and directed me to join in the lower post.
Because that time he has relieved. That's why this order is passed by the land tribunal.
No, 11th I have given my consent. 11th, there is no occasion to relieve me in absentia. I was then holding the post of IG.
It was written that due to and admissible to him, subject to the submission of application by him. MA number such and such is pending.
We are giving you liberty to file your rejoinder,
yes.
And that is to be, if you can say that within this period you will file the rejoinder, we can pass necessary order for expeditious disposal of the that original application.
Yes, but only my little prayer would be, you also may kindly protect me.
Has tell us that how much time you require to file that rejoinder.
The next it is fixed to within that time file.
All right. Take down. In pursuance of the order dated 10/4/2025, the Land Council for the Mr. P.K. Pari, Land Deputy Solicitor General, submits that counter affidavit has already been filed by the Union of India and copy has been served on the petitioner's counsel in the on the counsel for the appellant in OA number 67 of 2025. The Land Council for the petitioner submits that the petitioner has received the counter affidavit and he intends to file the rejoinder affidavit. He submits that the next date of posting of the original application is 1/5/2025 and the rejoinder affidavit will be filed in the meantime. If the rejoinder affidavit is filed and the pleadings are complete, in case the petitioner makes an application for expeditious hearing of the original application before the Land Central Administrative Tribunal, the same shall be considered favorably and the date fix of priority for 41. Preferably within a period of 3 months further. 3 months from the preferably within 3 months further. Accordingly, the writ petition is disposed of. I put a line like this. If since state of Orissa is also opposite, आपणकर state of Orissa होची opposite party number 1, 2, 3 ना. Then
2, 3.
The respondent
Oire
2, 3,
2, 3 and 4.
2, 3, 4.
Since the state of Orissa, so Director General and so on, so like the page number 72 are also parties. If they intend, they can also file the counter appeal, the original application in the meantime. After if the pleadings are complete, the necessary application for expeditious hearing is filed, then this one so we pass a favorable order directing disposal, taking steps for disposal of the original application within 2 months. Within 3 months. 3 months. Yes, next.
Small request, my lord, Mr. Rakesh Vera is appearing with me and I may be repeating.
Till then, the protection may kindly be given. Till then, my protection may kindly be given.
Yes, next.
My lord, may I have a little prayer, my lord? In the representation which was forwarded by the state government, that is pending for the MHA. Let the MHA, Government of India, pass necessary order on that application itself.
It is got a line like it is stated by the Land and Council for the petitioner that representation in
18th of March.
In 18th of March
was forwarded to the MHA, madam.
Now, which is that representation?
That is Annexure 1 by A in Plug B, madam.
Annexure 1 by A put the interim application.
Yes.
IA number?
IA number 6132.
6132 of 2025 is pending before so and so.
Before MHA, OP number 1.
It is open to the so and so to dispose of the representation in accordance with law. It is made clear that we have not expressed any opinion on the merits of the such representation.
Only I have a small request, my lord.
Yes.
This representation is submitted to the state of Odisha. Through state of Odisha, it go to the ministry, the home representative. If such application is forwarded, then the government of
It is forwarded on 29/3/2025.
If it is forwarded,
14076.
It is stated that the representation has been filed by so and so, and it has already been forwarded.
By letter number 14076. Top rail heights.
अच्छा, so लिखा है and annexure कितने होची?
1 by A.
1 by A देखी दे दे. IA number लिखा है जो 6132 of 2025 रे. तादिरे IA टा ऐसे जो page 6 रे होची. Annexure 1 by A होची. एवं ता ऊपर लिखा है जी जो हाथ रे लिखा है letter number so and so इटा ये जी से गुड़ा को
29/3/2020.
हाँ जो देखिए yes next.
Short span में से.
No, the presentation will be disposed of. We are directing for main hearing. Yes, next.
Till then, may I pray, my lord, protection?
No.
Item 12.
Item number 12.
This was listed on Monday, madam. And in this case, madam, the matter is that the land has been acquired by Bharatpur OCP area, madam.
Come little this side so that
similar matter has been adjudicated, madam, and the order has been passed to disposal of the representation, madam.
Do you want to go to a copy? Do you want to? Your representation in this petition is annexure 6, dated 6/5. Good type one. ତାଦେହରେ ବହୁତ ଜିନିଷ ଚେଞ୍ଜ ହବ ସେ ଏଇ ଟାଇପ ତାଦେହରେ ଅପୋଜିଟ ପାର୍ଟ ନମ୍ବର 2 to 6 କୁ ଡାଇରେକ୍ସନ ଥିଲା ଏଠି ଅପୋଜିଟ ପାର୍ଟିज ନମ୍ବର representation file is annexure 6 रे the dispose of program या दे जो पीरियड अच्छी कर देवे बाकी ऑर्डर गुड़ा ऑपरेटिव कर ले this लिखी देना this petition has been filed by the petitioner Antaryami Naik with a fair direction to the opposite party to provide employment as per R&R policy in lieu of the land acquired by LA case number 26 of 1985. The land council for the what is this writ petition which were annexed as annexure 5?
In annexure 5, my lord, collector pass a order to provide employment. Challenging that order, MCL came before this honorable, and honorable confirmed the order of collector. Then, my lord, MCL moved to Supreme Court. Supreme Court, it was decided.
It was
dismissed, my lord.
Dismissed.
My lord.
So now the order stands confirmed that they are to be given employment.
My lord.
Right.
Only the guideline that is at annexure 1, employment the running page 11, column employment 4. The present petitioner are coming under the category D.
D.
My lord. D re guideline they were those who are coming under D, they will be provided employment through the contractor if some vacancy, some requirement will be there. The grandfather of the petitioner is under the category D. There is no dispute over it. And hence he is coming under the as per the guideline. If any employment will be required by the contractor, he will be provided. No regular employment provision is there.
Supreme Court कथा तो लिखा ही नहीं कोई paragraph में.
लेकिन आते मुझे check कर ली से order तक को.
Can you give that order? Supreme Court order.
Review petition filed and that has been dismissed in 24 only. Then SL
government is checking नहीं आया तो फिर.
Bachelor on my receive the copy.
High Court order, adjournment order against the review the file is review dismissed, challenging that dismissal order. SLP was dismissed.
It is the case of the petitioner that his grandfather is a land trustee, and since compensation amount was not paid.
Yeah, compensation amount paid. He nominated his son to be for employment. Coming under category D, employment was not provided.
Compensation amount was paid.
Yes.
Though compensation amount was paid, where have you stated about that employment was not given, or which you approached the High Court? Which paragraph? You type of representation you do it one thing, you file a better representation. You MC dele kon hoba, itare kichi nahi. ଆପଣଙ୍କର କେସ୍ ଏମିତି ଆସିଥିଲା ତାପରେ ଆପଣ ହଁ ଏକ୍ଜେକ୍ଟିଭ ରିପ୍ରେଜେଣ୍ଟେସନ ଦିଅନ୍ତୁ that will be considered ଲେଖିଦିଅନ୍ତୁ ଶୁଣନ୍ତୁ ଏଇଟା ଲେଖିଦେବେ land council for the petitioner submits that though a representation has been submitted purpose before the collector on board opposite party number 2 but since it is not exhaustive now the petitioner is permitted to find a better representation giving all the exhaustive representation giving all the details in view of such submission the writ petition is disposed of giving liberty to the petitioner to file such representation before the opposite party number 2. Next.
14 is same one. Item 14. My stipulated dates maybe even to
Representation is filed within a period of
3 months.
ना कितने दिन भीतर अपन फाइल करेंगे
No, no, within 2 weeks. This.
along with certified copy of this order.
8 matters of similar matter is there. Right? I am moving the numbers. Yes, sir. Yes, sir. Yes.
12 and 14.
14 minute. 12 and 14. Okay.
Item 13.
May I please, Your Lordship? Order of the Central Administrative Tribunal is under challenge. That is Annexure 4, starts with page 70. Short point is, Your Lordship. Yesterday, Your Lordship has passed an identical order. That is, an employee who has discharged his duty in a post is entitled to get the scale of pay attached to that post, but not promotion. That is JTS Junior Time Scale Postal Office. आगे ସେଇଟା ମୁଁ ଆଣିଛି ଗଲା ସପ୍ତାହ ଥିଲା Lordship. In that case, Union of India has come. Here, Your Lordship, employee case dismissed, so employee has come.
Right, this is a different case altogether. So I need to file counter to this.
Obviously, you will file the counter. File order to
Same department?
Just a minute.
Madam.
The government servant is formally appointed. We can just inform order କିଛି Union of India challenge. ଏଠି ଆପଣଙ୍କୁ
Union of India also the same question.
ନାଇଁ ଏଠି ଆପଣଙ୍କର ପ୍ରେୟାର କୁ ଡିସମିସ୍ କରାଯାଇଛି. What is that operative part?
Operative part, your lordship, annexure 4 that starts with page 70. But paragraph 7 is the operative question, your lordship. Paragraph 7, your lordship.
Please come to that. Let us see.
Did my lordship get that starts with page 74. Admittedly, while the applicant was working as PS Group B officer, Postal Service, officer was ordered to officiate as Deputy Divisional Manager PLI, Office of CPMG Orissa Circle, Bhubaneswar in JTS Junior Time Scale Group cadre purely on temporary and ad hoc basis, while ordered dated 16/6/2006, A by 1 in the scale of pay such and such. Until further orders, and it was made clear that such ad hoc promotion would continue for a period of 1 year from the date of assumption of charge or till posting of a regular approved officer, which is earlier. In this capacity, the applicant continued for the period 16/6/2006 to 29/1/2007 as manager, Postal Printing Press, Bhubaneswar from 21/2007 to 1/2/2007, and again as the DDM PLI Circle Office, Bhubaneswar from 2/2/2007 to 27/4/2008. Thereafter, applicant was reverted to his substantive post of PS Group B by order dated 14/2/2008 A by 4, and as submitted by the respondent in the counter, the applicant consequent upon such reversion was posted as Assistant Director Staff on 28/4/2008, and again he was ordered to work as DDM PLI with effect from 29/4/2008 and to 30/4/2009. From the above, it is quite apparent that applicant's continuance in DDM PLI for manager Postal Printing Press, as the case may be, was not continuous. Therefore, the prayer, the applicant to grant senior time scale for the period from 16/6/2006 to 30/4/2009 prima facie appears to be misconceived. It is a fact that applicant by order dated 16/6/2006 was promoted purely on temporary and ad hoc basis to officiate as a Deputy Divisional Manager PLI in the scale 8,000 to 13,500, which correspondent to grade pay 5,400. This ad hoc officiating beyond having not got approved by the DOPT, the withdrawal of pay in JTS grade from 16/6/2007 to 27/4/2008 was objected in view of DOPT office memorandum dated such, as a result of which an amount to the tune of 19,230 was recovered from the gratuity of the applicant, which, however, was quashed by this tribunal by the order dated 3/3/2012 in OA number 503 of 2010. Knowing very well that the post of DDM PLI manager Postal Printing Press being a senior time scale carrying grade pay 6,600, applicant accepted the order of ad hoc promotion dated 16/8/2006 to the post of DDM PLI in JTS cadre, in which it was mentioned that scale of pay for the post of 8,000 to 13,500, which corresponding to grade pay 5,400 without any demur. Therefore, by quashing the impugned order of recovery, this tribunal in effect held that applicant was entitled to JTS Group A scale carrying grade pay sub beyond the period 1 year of his ad hoc promotion, notwithstanding the fact that same did not receive the approval of DOPT. It is to be noted that feeder grade for promotion from PS Group B to the JTS Group A cadre, the next promotion being the STS Group A. It is also not disputed that STS and GTS are interchangeable.
It is a case where the applicant has been allowed to discharge his duty against a post which is 2 steps higher than his substantive post with the scale of pay next higher post. The applicant has not challenged grant scale 8,000 to 13,500 GP 5,400 of the post JT while he was promoted to the officiate in the grade of DDM PLI purely on ad hoc basis, which is an STS Group A post carrying the scale of pay 10,000 to 15,000, grade pay 6,600. As noted above, the post of STS and JTS being interchangeable, applicant is deemed to have discharged his duty in the post JTS Group A carrying scale 8,000 to 13,500, grade pay 5,400 for the period in question, and therefore the claim as laid in way amount to superimposition of claim. For the reason discussed above, way is held to be without any merit, the same is accordingly dismissed. And so this is the impugned order. Now, Your Lordship, I draw Your Lordship's attention to earlier order Tribunal has passed. That is, Your Lordship will see.
Not to recover.
Not to recover, page 35 in way number 603 of 2010, para 5.
Subsequent cause of action responsible for his omission and commission. Thus, his claim for higher pay during such holding of such and responsibility is valid, and the respondents are under obligation to consider the same. Hence, since the applicant, even though retired from the service in the cost of so and so, but as he was never regularly promoted to the cadre of so and so, hence retired as so and so, hence his prayer for calculating pension. এটা পেনশনটা করে দেন বাট কয়েছে যে কেবল
I draw Your Lordship's attention to page 35, earlier order.
Will disclose it finally or notice new official, unless in any case the otherwise the whole time the government segment is the discharge of the government is paid in, and they may be employed in any manner required also without claim of additional either the services required from such as ordinarily remunerated from local funeral, where the government servant is formally appointed to fulfill the duties of the higher post in the same office is on the same federal sponsor. In addition to this, allowed the pay admissible to is appointed to officiate the higher post unless the operator to reduce it. Simplification.
May I draw Your Lordship's attention?
Yes.
That Your Lordship just have a glance to page 35, earlier order. Order passed in way number 603 of 2010.
They are the gratuity.
No, gratuity and also this fact, Your Lordship. Only I draw Your Lordship's attention.
30?
That is page 35, but operative portion page 42, paragraph 5. With Your Lordship's permission and precision. We find that there are two issues which need to be decided in this original application. A, recovery of 19,236 from the gratuity amount of the applicant, which is stated to have been paid in excess without authority for the relevant period from 16/6/2007 to 30/4/2008. B, this is important. Payment of salary in the senior time scale STS grade for the period 16/6/2006 to 30/4/2009, during which he had performed his duty in the senior time scale of DDM PLI. As issue at A above, the applicant has drawn the pay of JTS grade having been promoted on ad hoc basis. The fact that department did not take approval of ad hoc promotion beyond 1 year is not disputed. The fault is not attributed to the applicant. Hence, his continuance in JTS grade beyond 1 year without approval of DOPT though irregular, the applicant who has shouldered higher responsibility of the post cannot be penalized and is entitled to the salary drawn, especially when it is not the case of the respondent that the amount was paid due to the misrepresentation by the applicant. Rather, it was fault of the department that without taking approval from the DOPT, they have allowed him to continue in the JTS grade beyond 1 year. As such, we set aside the order of recovery from gratuity amount of the applicant.
So that has been done.
Then second, as regards payment of senior time scale to the applicant for the period claimed by the applicant is concerned, we may state that as per the instruction of DGP letter number such dated such annexure R by 1, a post will be deemed to be JTS if the holder is having a group A service up to 4 years, and in STS as and when he is promoted to STS grade through DPC after 4 years. But the fact of the matter is that the applicant had worked in the post of DDM PLI, which is a senior time scale post, but which break. Nonetheless, the department has accepted in its counter that applicant performed his duty of senior time scale post with break. Hence, in our opinion, the applicant should have been duly compensated for having discharged the higher responsibility for the relevant period. But it is noticed that the claim for getting senior time scale with a higher GP has been made by the applicant on 22/1/2010 after his retirement, having acquiesced in the pay scale JTS with lower GP. Again, this background, we leave it to the respondent to consider the grievance of the applicant for compensating him appropriately as per rule for having discharged his duty in the senior time scale, though he was substantively holding Group B post in the department. For the discussion made above, the respondents are directed to release the withheld amount of such and pass appropriate order regards to payment of STS scale within a period of 30 days from the date of receipt of
thereafter this petition, this
regarding payment of claim rejected. Again, I approach this and your lordship.
All right, this petition has been filed by the petitioner Pujya Bihari Ratha, challenging the
11 months order passed. That is the legit.
Order dated 22/6. No, which order you are challenging in this?
Annexure 4, your lordship, order of the administrative tribunal.
26 to
2007.
Prior to that, they are also filed another application which is pending.
All right. 22/6/2017 passed in OA number 768 of 2013. And outer order election the
review order,
and order dated 23/7/2024.
23/4 months. That's 23/4/2024.
23/4/2024 passed in review application number 260/0010 of 2018. The learned counsel for the petitioner submitted. See, you order to place court to
annexure
44.
That is your lordship.
44, no?
My lord. Your lordship.
No.
That is page 35. Page 35.
The petitioner, while working as Deputy Divisional Manager, Postal Life Insurance in the office of the Chief Postmaster General, Odisha Circle, Bhubaneswar, and retired from service on reaching the age of superannuation, approached the London Central Administrative Tribunal in OA number 603 of 2010, challenging the recovery of amount of rupees 19,236 being the overpaid salary by the order of the Director, Postal Account, Mahanadi Bihar, Cuttack, dated 18/1/2010, and with a further prayer, draw the pay scale attached to the post of senior time scale in Indian Postal Service Group A for the entire period, that is from 16/8/2006 to 34/2009, as he had actually worked in the post as per the orders of Chief Postmaster General, Odisha Postal Circle, Bhubaneswar. The said OA was disposed of as per order dated এটা কেতে disposal date টা ଦେଖିଲେ 2012 କେତେ ତାରିଖ ମାର୍ଚ୍ଚ 2012 ଲେଖା ହେଇଛି ପ୍ରଥମଟା 30 ନା କଣ was disposed of on 30th March 2012, and the Learning Tribunal framed two issues for adjudication. That is, A ଲେଖନ୍ତୁ ଏଟା page ରେ ଅଛି judgment page 42 ରେ internal page ହଉଛି 8 annexure 1 ର ହେଲା A ରେ ହଉଛି recovery of 19,236 from gratuity amount of the petitioner, which is stated to have been paid in excess and without authority for the relevant period from 16/8/2007 TO to 30/4/2008, and Roman 2, payment of salary in the senior time scale bracketary STS grade for the period from 16/8/2006 to 34/2009, during which had performed the duties in the senior time scale post of DDM PLI. The Learning Tribunal has been pleased to held that the recovery from the gratuity amount of the applicant is not sustainable in the eye of law, and accordingly the said order was set aside. So far as the payment of senior time scale to the petitioner is concerned, the respondents, the opposite parties were directed to consider the grievance of the petitioner for compensating him appropriately as per rules for having discharged his duties in the senior time scale, though he was substantially holding a grade B post in the department. The Land Council further submits that a order कौन है जो rejection कले अपन को कोटा सेटा
next annexure that is page 46
that a order की pass कले
assistant
director is he a party here?
My lord, that is New Delhi Minister of Communication and IT.
That after such order was passed by the London Central Administrative Tribunal, the Assistant Director
My lord,
General,
he is not a party to this question.
SGP, by order dated 22/5/2012. Victor, 22
Minus.
22/5/2012 rejected the claim of the petitioner, holding the same to be not admissible. This order was challenged in this original, which was challenged before the London Central Administrative Tribunal in what is that impugned order?
Your Lordship, when that is Annexure 4, page 70.
Was challenged before the London Central Administrative Tribunal, OA number 768 of 2013, and after the OA was dismissed, the review petition was filed, which was also dismissed as aforesaid. The Land Council for the petitioner submitted that in view of the ratio let down in the case of State of Punjab and another versus Dharampal reported in 2017, volume 9, Supreme Court cases 395, the orders passed by the London Central Administrative Tribunal on 22/6/2017 under Annexure 4, 23/7/2024 under Annexure 5 are not sustainable in the eye of law. He further submits that in a similar matter, the Union of India and the Chief Post Master General, Odisha Circle, Bhubaneswar, in WPC number 5178 of 2015, challenged the order passed by the London Central Administrative Tribunal in favor of the employee, and is not the wherein direction was issued to pay higher pay while officiating the post of Senior Superintendent RMS N Division Cutter, and the said writ petition was dismissed as per the order dated 17/4/2025. The order is taken on record. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the Union of India accepts notice on behalf of the opposite parties. Extra copy of the writ petition be served on the Land Council for the opposite parties. Matter be placed after 4 weeks. Counter affidavit, if any, be filed in the meantime. Yes, next.
One line may be noted is what citation they have given. Is not the self cutter or is not the same.
File your counter affidavit, highlight that. Yes, next.
Item 15.
Let the petitioner has challenged the order of dismissal dated 17/3/2025 passed by the London City Court of in order number 343 of 2020 minor. But in the prayer of this writ petition, inadvertently I have mentioned the date and order number incorrect manner. So I have filed an IA for correction or amendment of the prayer.
Where is that IA?
I have filed it is number manner 86853 of 2025.
86
6853 Manda.
6853 of 2025.
Manda.
When you have filed?
Today Manda.
Acha.
I have for copy.
I have not received the copy.
I have for copy.
For correcting the prayer portion only.
Only Manda.
All right. The land council for the what would be the correct number, way number, and order dated?
Manda. Order dated 17/3/2025.
Have you annexed that order?
Annexure 12.
12. And 14.
14 Manda.
Annexure 14. That is 17. 17/3/25 in way number 261. So upon kete likhchandi?
Lakhichi 524. That will be 343 Manda.
The land council for the petitioner submits that the petitioner T. Siva Dashan has challenged the in this writ petition has challenged the order dated 17/3/2025 passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack in OA number 260/00343 of 2020. But inadvertently, in the prayer portion, a wrong order, the date of the order, to also the number of the original application has been incorrectly reflected, for which he has filed an interim application, had IN number 6853 of 2025 for amendment of the prayer portion.
Right.
And yesterday and
today, man.
Oh, today. Let a copy of the interim application be served on the Land Council for the Union of India. Put up this matter next week.
I have already served.
No, I have not received the receipt for in
the office.
Submit that he has already served the copies once. Put up this matter next week, date with IN number 6853 of 2025 for consideration of these prayer for amendment.
I will pardon. As well as the date of my claim, that is 31st May 2020.
Prayer portion
say prayer is date of
to also the
date of claim.
Date of claim, है ना? तीन tag लग जाओ. Date of order, OA number और date of claim. ये वाला तो सब भूल लीजिए, ठीक है?
Bless you.
Item 16.
My lords, in items 16 and 17, this pertains to my lords' decision of the 10th of September 2024, where my lords have given detailed directions to the Union of India and the UPSC in relation to that IAS promotion case. Now, if my lords have item 16, which is contempt petition number 206, my lords will see at page 44 of my lord's judgment, at para 33, my lords had detailed certain directions that had to be complied with by the opposite parties. My lords have page 44. This is the first contempt petition, 206, my lord.
So, this has not been complied with. The first one is that opposite party number 2 shall convene a review
selection. Lords are given 3 months.
Okay. So,
yes, my lord.
So, who is in that opposite party number 2? Why have you made 3 parties here? The direction.
My lords, because the direction is, my lords, are to the OP number 1, which is the Union of India through the Department of Personnel. OP number 2, the Union Public Service Commission, which has to convene.
This has been.
My lord.
Have you received a copy of the contempt petition, Mr. No,
my lord. I have not a notice to go.
No, right. This contempt petition has been filed. for non-compliance of the order dated 10/9/2024 passed in WPC number 16303 of 2022. Stop. In the said order, in the operative portion, we have held as follows. Quote paragraph number 33 in its entirety. The Learned Counsel for the petitioner submits that none of the directions has been complied with by the opposite parties oblique contemners. Issue notice to the opposite parties.
September order?
Same order.
Yes, same order.
There are two versions. All right. Same. Yes, next.
Item 18.
Item 18 is received instruction.
What is your instruction? Consider the representation of the petitioner. So representation considered.
Yes, Lord. The sanction has already been made.
All right. No, थी तो अलगा कथा. खाली direction थिला representation consider को सेवड़ा है नथला बोली है. लेकिन the Land Council for the state has produced the compliance order dated 19/4/2025, which is taken on record. Accordingly, the contempt petition is brought. Yes.
I may pardon your lordship. This instruction that I have received, your lordship, this pertains to the sanction that has been made by the governor. This case, an amount of rupees 89 lakh has already been already.
While
sanctioned.
considering the representation, this order has been passed.
Yes, your lordship.
So this is compliance of that
Yes,
order.
your
What is
lordship.
there?
If he's agreed,
Yes,
he
sir.
yes, sir. Yes, your lordship.
If he's agreed, he can file it.
Yes, yes.
Yes, next.
Item 19.
Item 19, Lordship, I may be permitted to appear on behalf of Mr. Saurabh Tibrewal.
Valid to take addition on the representation. Yes, what happened?
Lordship, I need some time for the time.
Right, the Land Council for the state seeks some more time to obtain instruction as per the order dated 11/3/2025. Next month. Next.
Item 20.
May I please, Your Lordship? Your Lordship, I'm alleging the non-compliance of the order dated 18/9/2024. However, Your Lordship, I filed an IA for the amendment of the name of the contender, Your Lordship, because the name of the officer who was previously posted was reflected in the cause
Where is that IA?
On record, Your Lordship.
You are supposed to file an interim application for amendment.
Yes, Your
So
Lordship.
that you have not filed. The noting has come that interim application for amendment not yet filed. Have you filed?
I filed, Your Lordship.
What is the IA number?
164 of 25 and
Yeah.
165.
That is not on record. So that is IA number
164 of 2025.
25. I would have gone
Item 21.
No.
21 same na.
So let us do a contempt faster 958 of 2025. The Learned Counsel for the petitioner submitted that she has filed IA number 164 of 2025 for amending the cause title. Stop. Let the IA be placed on record. Matter be listed next week. Put a date there. Our next on IA number phone. Yeah, 165 of 2025. Set up next week for them.
My lord, one thing I want to brought to your lordship's notice. Item number 12. Item number 12. 31st April 2020 dispose of ହେଇଥିଲା ସେଟା upload ହେଇଛି item number 12 ସେଟା dispose of payment dismiss ହେଇଥିଲା ସେ order ଟା upload ହେଇଯାଇଛି ପୁଣି ଆଉ ଥରେ again
Now I search my lord.
ପୁଣି କାଇଁ ଆସିଲା ତାହେଲେ
ପୁଣି ଆଉ ଥରେ ହେଇଯାଇଛି
କାଇଁ ଅର୍ଡର କାଇଁ
upload ହେଇଛି
Upload ହେଇଛି net ରେ
ଦେଖିଲେ
ଦେଖିଲି।
10422
ବାହାର କଣ ଭାଇ
10422 by 2025
Delay ground my lord.
No, no. So you should have told us that we passed another order.
My lord,
ବର୍ତ୍ତମାନ
I
representation dispose of ପାଇଁ order ହେଲା କିନ୍ତୁ ସେଟା delay ground ରେ dismiss ହେଇଛି
ହଁ ତ କହିବା କଥା ଆପଣ
ସେଟା ମୁଁ ବି ଜାଣିନଥିଲି
ଦେଖିନଥିଲି ବି ମୁଁ ଏବେ search କଲି
No.
No, no, my lord. Now I search here.
order ତା ଦେହରେ ସାମିଲ ହେଇଯିବା କଥା କିଏ ନେଇଥିଲା ସେ ଡିକ୍ଟେସନ ଅନ୍ତର୍ଯାମୀ ନାହିଁ ଠିକ ଅଛି 22/4 order बाहर कर दूँ कॉपी एक्शन मैंने काली डिस्पोज ऑफ ହେଇଛି
21 ତାରିଖ
हां
21 ତାରିଖରେ
हां 21 तारीख अच्छा
ଆଉ ଥରେ କେମିତି ଲାଗିବ
how it has been listed why that order is not here in the
What about the next item?
next item ପଡିନଥିଲା
Item 14
Not reached that day.
Please, sir.
क्यों take down WPC number 10422 of 2000
खाली करছি अपलोड है ना
okay it was listed here who listed it it appears that the matter was taken up on 21/4/2025 and it was disposed of.
ଆପଣ ଏବେ ରିତରେ କାଇଁ କହିଲେନି
କହିଲି ଯେ ମଣ୍ଡେ ଆସିଲେ କିନ୍ତୁ ଅପଲୋଡ ହେଇଛି ବୋଲି ମୁଁ ଦେଖିନି
ଆପଣ ସାମ୍ନାରେ ଡିକ୍ଟେସନ ହେଇଥିଲା ଓପନ କୋର୍ଟରେ
କହିଲି
will you not tell that that matter was listed and disposed of
This is not proper.
ଲିଷ୍ଟ ହେଇଥିଲା ବୋଲି ମୁଁ କଲି
ये जो
ଆର୍ଗୁମେଣ୍ଟ ଷ୍ଟାର୍ଟରେ
और डायरी कौन देखी why it has been listed today if this order has been passed
ଓପନ କୋର୍ଟରେ ଡିକ୍ଟେସନ ହେଲା ଲେଚେସ୍ ପାଇଁ
posting for the inquiry
Dangerous thing.
Sure. Matter समय आपको
You should inform the court that it is listed and disposed it of.
ये dictation reach
Yes, item number 22, the issues are recurring on year basis. That's
will come tomorrow. I will mention.
Tomorrow. My elder brother has died 2 weeks in. Elder brother has died. For that I missed him. He died on 21st April.
Have you given that copy to the state council? You have filed an interim application for bail.
Yes, sir.
Have you given a copy so that you will verify?
Yes, we have solved it. Yeah.
Who has received that copy of the interim application?
They have served it in the office.
Why are you serving in office? Give another copy. Give another copy.
Today I did.
Give so that they will take the instruction through that IIC. This matter will be listed tomorrow. Right? Yeah.
Pardon me, mention my lord. Serial number 1 of 2024. Petition filed for the seeking for the interim bail, my lord. Due to his mother illness, mother suffering for and there is some surgery, my lord. So petition.
What do you want?
Interim bail, my lord.
You have gone on interim bail.
No. I filed for the IA for interim bail.
Okay.
Supplementary list, item number 1.
Please, the appellant has convicted under section 302 of the IPC and sentenced to rigorous imprisonment for life, your lordship. The operating part is at running page 41 and also.
Order admit call for the trial court record. Interim application for bail and stay realization of fine will be considered after receipt of the trial court report. The land counsel for the appellant says that the position of office of the witnesses to the land counsel for the state in the meantime. Yeah. Okay.
Item 2.
Item 2 on behalf of Mrs. Tota, my lord, paper and adjournment to next week.
mention is made on behalf of this Aditi Hota for adjournment with this matter of the summer vacation.
Lordship, I will pardon your Lordship. I do not have the deposition. I humbly pray that soft copy.
Take in your pen drive, you.
Yes, sir. Obliged.
Land Council for the State submits that is not having the deposition copy of the witnesses. Land Council for the State is permitted to take the deposition copies in its pen drive from the trial plant. Physical copy of the trial application.
Great. Item 3.
Kindly have a glance at flag C of item.
Yes, let him. Here is the report of the Senior Superintendent Secretary Korapu, bracket welfare services, from which it appears that the petitioner has been released on premature release guidelines 2022. Accordingly, JCRLA is disposed of if the petitioner, if the appellant intends to challenge the conviction, sees at liberty to file appropriate application for recall of the order for hearing on merit of the case disposal.
Item 4.
Unless the appellant has been convicted for the offence under section 498A 302 303 406 and 34 of IPC and sentenced to undergo imprisonment for life for the offence under section 302. My lord, the present appellant is inside the jail custody since 8/4/2015, more than 10 years. And my lord, so far as the case concerned, there is no eyewitness to the occurrence and not dying declaration of the deceased has been recorded.
We have granted bail to the mother-in-law.
Yes, my lord.
Norini alias Bagudi
Yes,
Beva.
my lord. On 3/12/2024.
Are the materials available against you? You are the husband.
Yes, yes, my lord, husband.
Dying declaration is there.
No dying declaration has been recorded.
So the case cause of death is burn injury.
Burn injury, my lord.
So your wife was staying with you.
Yes,
So what
my
is your case? How she died? Death? How she died? What is it? Let us see that accused statement. Your plea in the 313 statement, ଆମ ଘର ଜଳିଗଲା, ମୋ ସ୍ତ୍ରୀ ପୋଡି ହେଇଗଲା, ମୋ ନାଁରେ ମିଛ କେସ୍ ହୋଇଛି. That is in the accused statement. Last question you have told like that. So, five. Yes, what do you say? The room in which the dead body was found, first of all, that room was locked from outside, number one. And the hands and legs of the deceased were tied. So the question of that it is an accidental death or a suicidal death is ruled out. Right? So this is the condition in which your wife was found inside the room. And except telling that ମୋ ଘର ଜଳିଗଲା, ଯଦି ଘର ଜଳିଥାନ୍ତା ତ ସିଏ ବାହାରିକିନି ପଳେଇ ଆସିଥାନ୍ତା, ଗୋଡ ହାତ ବନ୍ଧା କେମିତି ହେଇଥିଲା, ଘର ବାହାର ପଟୁ କଣ ବନ୍ଧୁଥିଲା?
Suggestion has been given that due to short circuit, the house has been burnt and the wire has been
legs and hands are tied up, and from outside it was bolted. Question number 5. Question number 5, statement. 313 statement.
Prior, apart from the other things, they have stated also about the demand of dowry and torture, etc. And the intimation, same intimation was also given by the deceased on the previous day of the occurrence. That is PW 2 or 1 it is. No, PW 2 has stated that on 6/4/2015, my deceased sister informed me over phone that the accused persons trying to making plan to kill me if I would not give rupees 20,000 to them. 7/4 information paila the accused persons killed the deceased sister. Getting such information, I went to the spot, found the room in which my sister was locked from outside. With the help of the co-villagers, the lock was broken and we found that the hands and legs of my sister were tied and she was dead due to burning.
Because the doctor who is conducted the autopsy, he found that only on the waist a metallic wire has been tied up. The doctor who conducted autopsy, W18, he stated that one metallic fiber was found tied around the waist of the dead body.
No, you come to the deposition of PW2. So have you challenged it that there was no such that hands and legs were not tied?
That's because the autopsy doctor stating another contradiction.
So you are satisfied with that autopsy doctor's version?
There are both are contradict each other. And also the before arrival of the PW2, 100 to 200 people and the fire brigade also present, but they does not disclose anything. Para 5 at the last part, he also stating that I cannot say the name of the villager lock was broken. About 100 to 200 persons were present at the time of breaking of lock. But nobody of the co-villager has been stating anything about the breaking of lock. About the or about the pilot occurrence. No co-villager has been taken. And also the minor PW1 was stating that he extinguished the fire with the help of the fire brigade. They also does not disclose anything.
It's a brutal murder, you think. Killed your wife. It seems that it seems that କାରଣ ହେଇଥାଇପାରେ ସେ ଯୋଉ ସେ ଯାହା କହୁଛି ଯେ ଏଗୁଡାକ ବନ୍ଧା ହେଇଥିଲା ତାକୁ ଏତ ଖୋଲି ଦେଇ ପାରିଥାନ୍ତି ସେମାନେ କାରଣ ତାପରେ ସେ ଏତଲା ଦେଲା ପରେ ହିଁ ପୋଲିସ ଆସିଛନ୍ତି ତ ସେତେବେଳକୁ it clearly shows that it's a case under section homicidal death FIR টা দেখে list of exhibition. FIR ରେ ମଧ୍ୟ ସେଇଆ କହୁଛି ଆଜି ସକାଳ PW2 is the informant. ଆଜି ସକାଳ 9ଟାରେ ମୁଁ ଖବର ପାଇ ଯାଇ ମୁଁ ପାଇଲି ଯେ ମୋ ଭଉଣୀକୁ ଭିଣେଇ ଆଉ ଶାଶୁ ପୋଡ଼ି ମାରି ଦେଇଛନ୍ତି ମୁଁ ତୁରନ୍ତ ବରହମପୁର ଗ୍ରାମକୁ ଯାଇ ମୋ ଭଉଣୀ ଘରେ ଦେଖେ ତ ଭଉଣୀର ହାତ ଗୋଡ଼ ବନ୍ଧା ହୋଇ ସମ୍ପୂର୍ଣ୍ଣ ଜଳିଯାଇ ତାର ଘରେ ମରି ପଡ଼ିଛି ବାଙ୍କିରୁ ନିଆଁ ଲିଭା ଗାଡ଼ି ଆସି ନିଆଁ ଲିଭାଉଛି ତେଣୁ ମୋର ଦୃଢ଼ ବିଶ୍ୱାସ and this is the land council petitioner land council for the state in view of the relationship between the petitioner and the deceased and the manner in which the dead body was found inside the room as deposed to by PW2, the other evidence regarding demand of dowry and torture, and the medical evidence. We are not inclined to release the petitioner on bail stands rejected. It is stated that the petitioner is in judicial custody for 10 years. The official expedite the preparation of the paper book and matter be listed immediately after ensuing summer vacation for hearings. Yes, next.
Item 5.
Yes, item number 5.
My lord, does it allow the prisoner interval for a period of 15 days due to the death of this farm minor?
The land council for the appellant filed the surrender certificate of the petitioner, which is taken on record.
In the meantime, the person is also about 9 years. Prior to this matter, allows the interim for a period of 3 months. I filed this bail application. In the meantime, the occurrence had also allowed for 15 days.
No, that petition was for a particular purpose. So far as the pending petition is concerned, you were released on bail earlier.
Earlier, my lord.
That is the order dated
My lord.
6/5/24.
Yes, my lord.
All right.
6/24.
You let him obtain the report about your conduct. Will say that. IN number 37 of 2025. The London Council for the petitioner submits that the petitioner was granted interim bail for a period of 3 months as per the order dated 6/5/2024 in IN number 175 of 2023 and for a period of 2 weeks as per order dated 19/2/2025 in IN number 37 of 2025 and is surrendered at right time. Stop. Let the Land Council for the State obtain instruction regarding the conduct of the petitioner filed on interim bail. Put of this matter will be commencing from 5th of May 2025. These orders are to be communicated immediately, not that should immediately. Yeah.
Item 6.
Yes, item 6.
Let's call for the report regarding the conduct of the petition in interim bail notices.
Surrender certificate not received.
Would like to call for
अच्छा फाइल कर दिया surrender certificate of the appellant is on record. Stop. No such other application is pending.
the bail is pending notices.
Which one?
I number 229 of 24 notices.
That is for bail.
Yes.
Two 29 of 2024. That was disposed of on 8/1/25 and you are granted interim bail for a period of 3 months and thereafter you have surrendered. এই যে সারেন্ডার সার্টিফিকেটটা কেবে করা এটা তো পুরোনাটা What is the surrender certificate? ସେଟା ଆଗରୁ କାଟି ଦିଅନ୍ତୁ ସେଇଟା ମୁଁ ଡାକିନଥିଲି ଦେଖନ୍ତୁ the petitioner was directed to be released on interim bail for a period of 3 months as per order dated 8/1/25 in IN number 229 of 24. The Land Council for the appellant has not filed the surrender certificate. Have you obtained that report about the conduct? The Land Council for the state has produced the report regarding the conduct of the petitioner while on interim bail. So, your client has surrendered or not? The Land Council for the appellant has no instruction whether the appellant, after availing the interim bail period, surrendering before the trial court or not. Let a report be called for from the London Trial Court, that is Additional Session Judge Kemujer, in ST case number 24/137 of 2016, as to whether the petitioner, after availing the interim bail as per the order dated 8/1/25, has surrendered or not. Put of this matter in the week commencing from 12th of May 2025.
Item 7.
May it be acknowledged. Possibility certificate was confirmed
In terms of the order dated 10/4, you are saying that you have not received the custody certificate and otherwise this 10 days time.
Twice, not IA number 762 of 2020. This is an application for bail. The Land Council for the state submits that as per order dated 10/4/2025. ଆଗରୁ order ହେଇଥିଲା ନା
ଆଜ୍ଞା 47/3/2025
25/3/2025.
ଆଜ୍ଞା
As per the order dated 16/2025 and 10/4/2025, he has already taken steps for production of the custody certificate of the appellant and also to obtain instruction regarding criminal antecedent against the appellant, if any. And the matter may be taken up a week after. This matter will be commencing from 12th of May 2025.
Problem.
Item 8.
Item 8. Here the petitioner is convicted under section 302 of IPC matter for life imprisonment. The present petitioner is in custody since 4/6/2019. Deceased is the wife, petitioner is the husband minor. Cause of death is the septicemia shock minor, pouring the kerosene and put the fire on the body of the wife minor. As per the witness of the doctor minor, who is the PW1, he technically stated that the petitioner also having the injuries in his leg and hand injury, burning injuries minor. No direct evidence is involved in there, only circumstantial evidence.
No, dying declaration is there.
Before whom?
The executive magistrate. PW 17 mechanical 17 mechanical. The husband and wife were residing in one room. While he was in the morning while asleep, they have poured the kerosene and set fire. The husband is the conduct of the husband is shown that how they both are eloped and they are married subsequently. PW 17 mechanical on 5/6/2009
Time declaration has been recorded by the executive magistrate by exhibit 11. But the same being a Xerox copy, the document cannot be convicted. But if it has some corroborative value, as it was recorded by the executive magistrate with proper procedure. Secondly, the prosecution has oral dying declaration as proved by sworn. So dying declaration में जोड़ा oral कौन पूछी कहाँ implicate पूछी
PW 17 mechanism. In presence of doctor and some witnesses, the executive magistrate, the additional Tahsildar Malkanagiri.
The deceased was, of course, able to talk. I had asked the deceased about the circumstances on my query. The deceased told that on Saturday her husband was in an intoxicated state, as having consumed liquor, and he had asked her to serve food, but by then she had not cooked, for which her husband left the house on anger, and that in the night both of them had slept together, and on 4 a.m. while she was in sleep, her husband poured kerosene of a jerry can over her body and she had protested, but the accused set fire by means of matchbox, and that when she had reached south, the neighbors rushed to the spot and shifted her to the hospital. So dying declaration is there.
Dying declaration is there.
Oral
And like
declaration
she
of TW5, oral declaration is
she
there.
stated that when I am laying on the bed, the kerosene was poured into the my lord. But in PW one, my lord, who is the doctor, in cross examination, lordship page number 11 in my petition. Yes, the doctor said that the she is the victim of the incident and that at the time of burning she was in standing posture. Can I read the paragraph, my lord? During cross examination,
PW1.
First paragraph, PW1. During cross examination, the doctor has stated that in the case of deceased summary journey, the self-incrimination was not possible as palm and the inguinal areas were not involved, and that the soul would not be affected when she would be in standing posture.
Yes. If he would have been
Sir,
standing
general,
position,
if
he would have standing position, this time injured, but he was sleeping and set fire was made by power accuracy.
ଯୋଉ ଜାଗା ଗୁଡାକରେ କିରୋସିନ ପଡିଛି ସେଇ ଜାଗା ଗୁଡାକ ଜଳିଛି ଆଉ କଣ?
Petitioner ବି 4 days admitted in hospital injuries, ତାଙ୍କ bodily injuries ପାଇଁ.
ହୁଏ ତ ଟସଲ କିଛି ହେଇଥିବ, କଣ ହେଇଥିବ କିଏ ଜାଣିଛି କଣ ତା ଭିତରେ ସେଠିକି ତ କେହି ଦେଖିନାହାନ୍ତି ଯାହା ଡାଇଂ ଡିକ୍ଲାରେସନ ଦ୍ଵାରା ଆସୁଛି। ଯେତେବେଳେ ମାନେ ଇଏ ପକେଇଥିବ ମାନେ କିରୋସିନ ପକେଇଥିବ ଉଠି ପଡିକିନି ପ୍ରୋଟେଷ୍ଟ କରିଥିବ ଏବଂ ତାପରେ ଏଇ ସବୁ ଜିନିଷ ହେଇଥିବ।
TW5 also was the neighbor by MC. Bail condition, it's a very.
On my asking, she told that her husband poured kerosene and set fire. My mother reported so and so. Executive magistrate recorded this. How do you get over this dying declaration? And if it is acceptable, apart from the oral dying declaration, which is deposed to by the other witnesses, the executive magistrate has also stated that what she stated, and doctor also has noticed burn injury, and it is the cause of death.
But she might require some time so that I collect the evidence of the man.
Why are you arguing this matter then? If you are arguing a 302 case in High Court and you are not having deposition copy and you dare to argue a bail application in 302 in the High Court.
No, prisoner fiction, I appear my.
You should have said so. Why you started arguing the case? The learned counsel for the this is item number 8. Period the prisoner's petition at flag C for engagement of advocate Tapan Jyoti Pani instead of advocate Gopinath Mishra. You have filed your wakalatnama?
Yes, sir.
Mr.
S.K.Sahoo.
Mr. Jivanjyoti Pani has filed wakalatnama, which is accepted.
Tapan Jyoti.
Yes, sorry, Tapan Jyoti Pani has filed the wakalatnama, which is accepted. The name of Mr. Gopinath Mishra and his associates shall not be reflected in the cause list. The paper book has been prepared, so you take a copy of the paper book. Yes. Since Land Counsel for the petition appellant submits that he may be supplied with a copy of the paper book. Let a copy of the paper book be supplied to the Land Counsel for the appellant by the registry. Copy note sheet ଦସ୍ତଖତ करना है ଗୋଟେ paper book ଗ୍ରହଣ କରିବ matter to be listed after summer vacation.
Sorry, ma'am. Wait.
Yes, next.
Item 9.
Maybe.
There are two interim applications.
That is IA number 1110 and another number 24723.
One appellant.
One appellant.
Why two?
One appellant, that appellant will not face for that.
Which one?
IA number 111021.
21 or not face? Look on IA number 111021. There is an application for bail and counsel for the appellant submit. That seems another interim application has filed for bail. He does not want to place this application. Accordingly, IA is disposed of as not placed. Yes. Your bail application was never rejected on merit. You have got the deputation copy with you.
The paper book has been
Paper book prepared. So, what is the prosecution case?
On the date of occurrence, this appellant and his wife was killed. The petitioner assaulted his wife and killed her.
Eyewitnesses are there.
Yes, madam. 3, 4, and 12.
3, 6, 12.
3, 6, and 12.
3, 6, and 12.
4, and 12.
Check for
3, 6, and 12.
3, 6, and 12. And doctor?
And that is PW 8.
Cause of which is due to combined effect of massive hemorrhage and neurogenic shock resulting from the or laceration of the left side of the natasha. So, what do you say?
The custody since 7/3/2014. About 11 years in custody. 7/3/2014.
Final point.
11 years.
ଆପଣ ନାଁ ହେଲା କଣ?
ଶଙ୍କର ସାହୁ alias ଶଙ୍କର ସାହୁ।
ଶଙ୍କର ସାହୁ ଦେଇଛନ୍ତି 8/3/2014। You are never released on bail during trial.
Interim I released for 10 weeks.
No. During trial.
During trial.
Yes. No. Why this on court? The trial I have not released.
Combined reading of PW9, who is the daughter of the deceased and the appellant, and PW3/600 show that on premeditated manner he prepared himself to kill his wife.
No, what are you raising that the man is in custody for 10 years, more than 10 years.
Yes, sir.
So
11 years.
11 କେମିତି ହବ? ଆପଣ 8/3/2014 ରେ କଷ୍ଟଡି ଗଲେ 10 ମାସ ଆପଣ କହୁଛନ୍ତି ବେଲ ରେ ଥିଲେ।
10 weeks.
10 weeks. And counsel for the state. Land counsel for the petitioner submits that the petitioner was taken into judicial custody on 8th 2014 and he was never released on bail during trial. And during the pendency of this appeal, he was granted interim bail for a period of 10 weeks. And after availing the same, he surrendered at right time. Land counsel submits that there are good chances of success in the appeal, and therefore the bail application may be favorably considered. Land counsel for the state, on the other hand, opposed the prayer for bail and submitted that 3 eyewitnesses to the occurrence, that is PW3, PW6, and PW12, have stated that the petitioner dealt tabula blow on the left neck of the deceased Uttam, as a result of which the deceased died, and the evidence of the eyewitnesses get corroboration from the evidence of the Dr. PW8 who conducted post-mortem examination and opined that the cause of death was due to combined effect of massive hemorrhage and neurogenic shock resulting from caught laceration on the left side of the neck, and the injury is homicidal in nature. Considering the submission made by the Land Counsel for the respective parties, the evidence adduced by the eyewitnesses, the corroborating medical evidence on record, while not inclining to believe the petitioner on bail on merit but taking into account the period of detention, judicial custody for about 11 years, and absence of any chance of early hearing, we are inclined to release the petitioner on bail for a period of 3 months. While on interim bail, the petitioner shall not indulge in any criminal activities or try to violation of any terms and conditions that are enter cancellation of bail. Kinimas for a date for surrender certificate. Or ye fund of certificate. Yes, next.
Item 10.
Last time I was directed the state to take instruction on the medical certificate filed by the petitioner in the present interim bail application.
Whose health condition?
Petitioner smart.
कहाँ देव पर मां करो ना
हाँ
सर मानो के बापा है
वो लिखे प्रेसिडेंट किस बापा
मां लिखी
जानकी वल्लभ यही तो सेते but I have said the
जानकी वल्लभ केमती मां हो
ऐसे लिखा ही है अब सीधा
जानकी वल्लभ माने जानकी पर स्वामी जी ऐसे जानकी खाली था हम ज्यादा Good lecture the on asla diyan report diyan. Suffering from various physical diseases and treated and got tests and so on so. Kidney and heart problem, he attended medical attention.
It was during 2014, 17 and 20.
No, तापरे आउटे 6/3/2025 रे तार किडनी हार्ट प्रॉब्लम पई आस्तिला हॉस्पिटल प्रेस्क्रिप्शन ये अच्छी
and prescription for
will be admitted there for the better treatment of the health treatments also. His wife Sanjukta, daughter-in-law, 2 grandsons, Pondar and Egarbots were present with him in the family and taking care of them. Another son, Janaki Bollavo, only one son, left the house in Shillong, living in Pune. Janaki ki Janaki Santosh Polli.
Janaki Polli is the father of the appellant.
नहीं देह खराब ही कहा रहा
जानकी वल्लभ
अच्छा
earlier my lord was granted me
No,
1
no.
month bail.
ଏବେ ତାର kidney ଆଉ heart problem ପାଇଁ treatment ହେଇଥିଲା
And
6 3
it was, I had a conversation with the person who was conducted the interview. He stated that the appellant's father, he said that I was having the problem of kidney and heart. That's why I went to the hospital. And the Your Lordship, may kindly see the paragraph 2 of the IA for a minute. May I read?
paragraph 2 ରେ ସେ ପୁରା କହୁଛନ୍ତି father ଜାଗାରେ mother ଲେଖି ଦେଇଛି ଭୁଲ ରେ
That is inadvertent. That I concede, Your Lordship. That is
ଆହୁରି ଅନ୍ୟ ଜାଗାରେ ଲେଖି ଦେଇଛି
Your Lordship, may kindly see shifted to some hospital, and after necessary treatment, concerned doctor after due examination has found cerebral vascular accident and advised for immediate neurosurgery.
ତା ଯୋଉ patient ଇଏଟା ଦେଇଛନ୍ତି medical certificate ଟା
There is nothing to suggest that surgery is required. There is nothing to suggest that he is suffering from cerebral vascular accident.
ଲେଖା ହେଇଛି ମିଷ୍ଟର ଜାନକୀ ବଲ୍ଲଭ ପଲାଇ ଲେଖା ହେଇଛି ବୟସ ଲେଖା ହେଇଛି 75 ବର୍ଷ
Yes, sir.
4 ମାସ
The complaint he was having the headache and sudden loss of conscience.
କଣ crime କଣ କରୁଛି
376 302 years.
3 persons more than 10 years in custody and cannot grant him entry bail for 1 month.
From time and
because
he is trying to be released on
see
entry
the
bail
last order also.
on the
That is IA number 508 of 2022. Sorry, IA number 1244 of 2024.
he was granted entry bail on 21/5/2024, Your Lordship. Thereafter, he filed another application on account of illness of his mother, which was withdrawn also. Thereafter, this application has been filed. He has taken a ground that immediate surgery is required, whereas the prescription enclosure that doesn't show any such emergency, Your Lordship. There is only referred that consultant neuro. And he is around 75 years.
Adverse reported when he was released on interim bail for a period of 2 months by order dated
21/5/2024. Yes, sir.
That was taken on the ground of ailment of the wife.
Wife, Your Lordship.
Because each time such type of applications are filed,
Time and
we
again,
used to take instruction through you.
Yes, sir.
And after receiving the instruction that the medical documents are genuine and this is the condition, his presence is so. Last time, well, also we granted bail on the ground of ailment of the wife.
That she required some surgery.
So now it seems that father, of course, he has written mother, but father's statement, and this is the problem.
Let them file subsequent. You should kindly see the prescription. It has been advised that he has to go for the CT scan and consult the neurosurgery department. Let them file any document that effect that they have undergone that diagnosis.
ये आर माँ अच्छी आर स्त्री रहुची आउ आर दीटा पिला अच्छी बट दीटा का माइनर 17 और 11 for the state. At the outset, Land Counsel for the petitioner submits that inadvertently in the interim application for bail, it has been mentioned that the mother of the petitioner is ailing. In fact, the father of the petitioner, namely Janaki Vallabh Pallai, is suffering from different health related issues, and the medical document has been annexed to the has been also filed. The Learning Council for the state had order dated 7/4/2025 and 21/4/2025 has been asked to obtain instruction on this interim application. Today, the Land Council for the state has produced the written instruction received from IAC Nirakarpur Police Station dated 22/4/2025, from which it appears that the petitioner's father apart from his physical illness and age-old problem, is suffering from kidney and heart problems, and he attended medical attention at SOM Hospital on 6/3/2025. And there are other family members in the house. And will be admitted for betterment of his health condition. And there are other family members in the house. Stop. The report furnished by the Land Council for the state is taken on record. The Land Council for the petitioner further submitted that the petitioner was granted interim bail for a period of 2 months. अच्छा 1 month.
One part mentioned 1 month there. On the below
For a
2 months.
period of 1 month, as per the order dated 21/5/2024, in IA number 1244 of 24, and after availing the same, he surrendered at right time. You have this surrender certificate you have filed. Considering the submission made by the Land Council for the respective parties, the fact that nothing adverse has been brought to our notice by the Land Council for the state regarding misutilization of the liberty by the petitioner while on interim bail as per order dated 21/5/2024, and taking into account the averments taken in the interim application, the medical document annexed thereto, and the report furnished by the IIC Nirakarpur Police Station, we are inclined to release the petitioner on interim bail. The matter be listed on such and such date. Land Council for the appellant shall file the surrender certificate. Yes.
Item 11.
There is no name number in the family, and the two sons of the petitioner are minor. Yes. See, they report to the court. Yes, sir, Mr.
In 11, I appear in 4 appeals. 902, 914, 966, and 1000.
Yes.
My learned friend appears in the past metamulate way. Serial number 924 of 2003.
It is that double murder case of Mahanga.
Yes.
Yeah. So witnesses are there?
There are no eyewitnesses.
Then?
There is an oral dying declaration alleged to have been made before the family members of the deceased.
No other evidence?
Yes.
So let us take note. So what are the, have you prepared any chart to that effect? That what are the materials?
I have sent it by WhatsApp notes to the
move bail application for all the accused separately.
Yes, in each
Separate
appeal, separate bail application.
Bail म्हणजे पेशंट ना. Have you prepared a chart?
Are you ready for final hearing?
Of the appeal?
Yes.
Can be done, but as your lordship knows me, lordship, your lordship grants bail, then hearing of the appeal becomes easier.
Paper book already ready.
So let us hear this matter. If you are prepared, we can start it today also.
See, there are how many appeals are there?
For final hearing next week, so I will also collect the criminal and
What I am saying is,
if it is oral dying declaration only, then it will not take much time. Can fix it.
In the general appeal 1066, Contempt city, there is another allegation that leading to discovery of the information.
There are 8 appeals. 8 bail applications has to be heard separately.
It would be better that we, in that time, we can hear the criminal appeal also. Subject to your ready.
lordship was pleased to hear in extenso at the time of bail also. So it will be easier. I can
Yes,
Your lordship has granted bail to almost all of them during trial.
No,
At the end of the trial.
So get ready. We'll take up this matter.
Let us start today.
30th. No, he's not ready.
No, I am ready, my lord.
No,
Yes, I am ready.
We are little difficult.
So
For final hearing, I need some note. That's
let us say, tell us that which date, the next week or any date you say, so that we can finish it off prior to this summer vacation also.
Problem your lordship was early morning court and day court.
No, if you are ready, that is why exactly we are asking you. So now, Mr. Panda, you are telling about the morning court. Think of those days when in that hot, we are now, today also
We are thinking of
wonderful days, Miller.
now we are thinking of having a evening court now.
After going home in the heat, eating pakala and sleeping was ideal, Miller.
That's right. Now evening courts are also.
No, evening courts will not probably only judges will sit there.
evening court है preparation.
No, ये would have hearing matter, appeal, revision, etc. ଆସିବେ ସକାଳେ ରାତି 10ଟା
Next, you already am back to Miller.
ଗାଳି ବନ୍ଦ କରିଥିଲେ ଆମେ ସଫା କରିଦଉ।
କେତେ ଦିନ ପୂର୍ବରୁ ଘଟଣା
just before half an hour 28 ତାପରେ before 2 month ହଣ୍ଡା ଦେଇଥିଲେ ପଜେଇବା ପାଇଁ ଗୋଟେ ବ୍ଲାକ୍ ସ୍ମିଥ ପାଖରେ leading to discovery PW12
ଖଣ୍ଡା ସେ କହିଲେ ତ
ଇଲେକ୍ଟ୍ରିକ କନେକ୍ସନ ଟାକୁ କାଟି ଦେଇଥିଲେ। ଷ୍ଟ୍ରିଟ୍ ଲାଇଟ୍ ଯୋଉ ଲାଗିଥିଲା ସେଟାକୁ କାଟିଥିଲେ PW32
ଘଟଣା କଣ ଦିନରେ ହେଇଛି ନା
ରାତିରେ ସନ୍ଧ୍ୟାବେଳେ 7:30 ଏ ଷ୍ଟ୍ରିଟ୍ ଲାଇଟ୍ ଟା କଟାଥିଲା। Extrajudicial confession before PW18 he hostile but admits that he has given statement before the magistrate 164 blood stain detected from the dress of one of the accused and it was matched with the deceased. Blood stain detected from the sword that was also matched one of the deceased.
And what is the oral dying declaration?
Oral dying declaration, all the accused persons have asserted by means of weapon.
ଦି ଜଣ ଯାକ କହିଛନ୍ତି ନା ଜଣେ
ଜଣେ କହିଛି
ଦିଟା ଜାଗାରେ ଦି ଜଣ ଯାକ କହିଛନ୍ତି at the spot where they were found one of them is stated to have made the declaration to his son and to two others the other deceased Millard on the hospital on the way to the hospital he has given
ambulance
from Salekund to Kat. Not from Manga to
not from village to Manga but from Manga to
the opinion of the doctor is completely different.
କିଛି ସାକ୍ଷୀ ଅଛନ୍ତି ଯୋଉଠି କୋର୍ଟରେ ଆଉ କିଛି ସାକ୍ଷୀ ମାନେ ଡାଇଂ ଡିକ୍ଲାରେସନ ଆଉ ଯୋଉ ଆମ୍ବୁଲାନ୍ସ ର ଯୋଉ ନେଇକି ଯାଉଛନ୍ତି ସେମାନେ କହିଛନ୍ତି ଡାଇଂ ଡିକ୍ଲାରେସନ ଏଇଟା
same set of witnesses.
ନାଇଁ ସେମ୍ ସେଟ୍ ନୁହଁ
Same सात ରୁ 11
different set and independent also there not only family members.
And the ambulance, the pharmacist who was there inside the ambulance, he didn't. The pharmacist who was inside the ambulance, he didn't support.
No, that is a merit. I just overall କଣ ଅଛି ସେଇଥିପାଇଁ so ଦେଖନ୍ତୁ so this criminal appeal ଗୋଟେ order pass କରିଦେଲେ along with the connected criminal appeals have been listed for consideration of the bail application. But since the paper books have already been prepared and the learning council for the respective parties have no objection for hearing of the criminal appeals, on consensus of all the parties, the matter will be listed on 12th of May 2025 at 2 p.m. for hearing. Yes.
The convenience note has been filed.
The note which is filed is taken on records. So just prepare this argument note gist ये बेसी गुड़ाक इलाबोरेट करिवेनी और यदि citation देबे किछि ए paragraph just short रे ये करिके yes next
Item 12.
12 was there yesterday and you will also start here. Here, my lords, the conviction of the appellant is under section 302 IPC.
Last document also read what is the custody certificate as well as the status of that child.
Child माने कहाँ
माने deceased रो पिला appellant of deceased रो पिला
ଝିଅକୁ ମୁଁ ବାଡେଇ ମାରିଦେଲି ଏଟା ତ ସେ କହିନି ତାର ଏଭିଡେନ୍ସରେ କହିନି
କଣ ହେଇଛି ଏଭିଡେନ୍ସ
ଏ ଯୋଉ ସେ ମତେ କହିଲା ତମେ ମାନେ ମୋ କଥା କିଛି ବୁଝିଲନି ମୁଁ ଶେଷରେ ଏଇଆ କଲି ତମ ଝିଅକୁ ମୁଁ ବାଡେଇ ମାରିଦେଲି this has not been stated in the evidence of PWC.
Which PW 26 then? 26. Which statement of PW 26? It must be 6. In that same paragraph, it is.
26 ରେ ହେଲା scientific officer. It relates to PW6 million, not 26.
Yes.
That's a typo error.
Typo, that's what
Reading the above para, I do not find any contradiction in the evidence of PW6. Rather, I found him trustworthy. Consequently, I found prosecution has proved beyond all reasonable doubt the aforesaid circumstances. Although law is well settled that conviction cannot be solely based upon official confession of accused, and it's a weak piece of evidence, and court should look for corroboration. Shall I place the evidence of PW6?
No, I was just we are going through it. So how this accused is related to the PW6?
PW6 is the foster father of the deceased. She is the Mausa of the deceased. She was brought up from her birth, soon after her birth, by PW6, who is a co-villager of the appellant. And appellant and the deceased, they fell in love with each other and got married. So the question
put to the statement.
Yes, next.
Item 13.
Lord, in the last time, Lord was pleased to ask the Learned Council states as to the status of the other accused persons. I have also collected, with his permission, I have also collected. There are other appeals arising out of the same incident, but since there is split of trial.
No, speed of trial, the evidence may be also different.
Yes.
So you focus on your case.
Yes, then the Lordship was asking that.
ठीक अच्छे अपन डिपोजिशन कॉपी दे दी जल्दी स्टेट काउंसिल के what instruction was sought for
Status
regarding status and any other appeals are pending. Apart from this, there are another 3 appeals are pending.
no see କହୁଛନ୍ତି 3 appeals से सेटा होची split up case है तो से केस रे हुए तो जे PW1 ହେଇଥିବ सी हुए तो एथरे PW1 नथिबो कारण सेमानकर ट्रायल सरी गला ହେଲା ସେମା ଇଏ ପଛରେ ଆସିଲା ନା ସେମାନଙ୍କ ଟ୍ରାଏଲ ସରିଗଲା ଜଜମେଣ୍ଟ ହେଇଗଲା ଇଏ ପରେ ଆସିଲା ତ ସେ ଏଭିଡେନ୍ସ ତ ଆଡପ୍ଟ ହବନି again the witnesses has to come they have to give evidence and cross examine ତେଣୁ evidence ବି different ହେଇଥାଇ ପାରେ exactly same ତ ହବନି ତେଣୁ better focus on this case. So what evidence, let us see what instruction you have received. এটা কোন এটা
Status of the other court one bear ଥିଲେ appeal 4-8
वो जो 11टा accused ଥିଲେ इतने तो ये judgment देखुची जे there is only one accused तो जो split up case रे 11 जन ଥିଲେ so divide that. Now tell us what about this appeal, what is the prosecution case?
Yes, prosecution case is long. The deceased, along with the his son and other 2 witnesses, were proceeding towards the house of the PW6 in front of the accused Bhagirathi, in front of the house of the accused Bhagirathi. All the accused, but there are named 15 accused persons named in the affair. They indiscriminately assaulted the deceased.
It's a political rivalry.
Yes, political background because this is probably belonging to Congress and they belonging to the ruling party. That is
2014 during that election at assembly election. 14 Mishra. So eyewitnesses are there.
Yes, eyewitnesses there.
Who are the eyewitnesses?
But eyewitnesses are relied upon from PW 11, 13, 15, 20.
PW11 is an eyewitness.
Yes. 11, 13, 14, 20. And 12.
11, 13, 14, 20.
They are also injured.
12. 12 Herman and son.
नहीं, injured eyewitness किए? समझते?
Injured eyewitness से 11, 13, 14 and 20.
अच्छा ठीक है.
Yes, injured.
They are also injured. अच्छा गोटे eyewitness को आसंती. PW
may start from 12.
12 टा कौन आपन ना कही नहीं ना कौन? इस पे आगु प्लेस करियो क्यों?
नहीं.
They are eyewitness but not injured.
कौन पढ़ो? 12 टा पढ़ो. What is the how many numbers of deceased?
Only one.
ना कौन?
Arjun Ben. Arjun Vera is the deceased.
Oh, there. Oh, pardon. Right. या ना कौन गला ये अपलन ना? पंचानन दास अलिया और पूजी.
पूजी alias पंचानन.
Yes, 90.
तो ना अच्छी है ठीक है पंचानन alias पूजी.
Yes,
you are armed with iron rod and deadly weapon. General statement. तापरे
The attribution is lucky.
Wife and daughter of so and so wala. Accused persons attacked us with deadly weapons. Babaji Varik intervened to rescue. So and so mine. It was she. ता बापा ना कौन होती या बापा ना उसी कौन late Arjun. Asha, this is the this PW 12
is the informant son and was accompanied with the eyewitness to the incident.
और जो ऊपर कौन लिखा है कि I am the wife of late ये son वाला
ये भूल ही है
तो PW 12 is the son of the deceased.
This is an informant.
How yes
Not page 19
is also the informant. So no, this specific line which is there.
Line sixth line from the bottom.
Ponchanono alias Guji dealt a blow on the head of my father by means of thenga. My father fell down. ये गोटे लाइन अछि तापरे
11 also said the same thing. 11 also said the same thing.
11 Panchanono by means of thenga.
So who is the doctor?
Dr. Miller, PW.
The doctor who conducted PM.
PM is Dr. PW 9. He found 3 injuries.
Just one.
PW 9, Dr. PM.
Page
so, 6. Lacerated wound on the scalp, on the right side forehead, intracranial hemorrhage, lacerated with compound fracture of left humerus, then laceration of the left leg, compound fracture of tibia fibula. So this head injury rohichi ebong dissection ne madhya asila. Cause of death madhya opinion dele due to shock and hemorrhage, injury to the vital organ like brain, right? So bamboo lathi taku madhya ebong iron rod taku examine karikini se कहले जे injuries are possible. So apart, you are right that the witnesses have implicated the other accused.
Yes.
But so far as
recovery from the
so far as the your overtact is concerned, that is specific that you are the only person who assaulted the deceased by means of a thenga on the head. अन्यमाने मारथिले कुआउची deceased को आउ किए मारले बिल तो evidence नहीं except you.
But this weapon of offense recovered from the house of Bhagirathi. From the house of Bhagirathi. अन्य कहीं ना
एटा आगे कौन तो
attribution टा मोनारे कहते हैं witness माने on the head.
So accused persons who have assaulted the injured persons have faced trial and found guilty under section 302 also.
149.
302 149. They have been released on bail. But your case is distinguishable from the other cases.
Other cases below.
And that apart, you absconded for how many years?
Lord, I was also during trial bail.
You are on bail. So split up from bail.
Split up nahi. Lord, I was arrested. In the case, I was arrested.
Trial court record
27/3/2015, I was arrested. Then I continued incarceration 2/7/16. Then I went on bail, interim bail. And there, my lord, again I was arrested on 15 December 2018. And since 18 till date of
केते वर्ष रहिलेनी
5 वर्ष 4 मास 5 मास
नहीं जजमेंट के बेला
जजमेंट है लागे 25/3/25 25
जजमेंट
आज्ञा
जजमेंट होची Judgment ହଉଛି 17/3/2024 ଲେଖା ହେଇଛି 17/9/24 and when in the judgment it is mentioned in the first paragraph page that by that time you are in custody for 3 years 6 months 27 days last column and ଯଦି ସେଇଟାକୁ ଏଠି କରିଦିଆଯିବ ଯେ ନହେଲେ 10 11 12 ଆଉ 4 ମାସ 7 ମାସ ତାହେଲେ making 4 years some months that would be there. 1 month 4 years 1 month. So any criminal antecedent against this man because these are political persons. This the informant and family members are they are one political party. The accused persons are political party, another political party. So have you taken instruction about the criminal antecedent? Get that instruction. We'll take up this matter next week and also produce that custody certificate. Right? The land counsel for the petitioner state has filed the written instruction received IIC all police stations relating to the criminal appeals filed by the accused spirit of trial, which is taken on record. The London Council for the IN number so and so like there is an application for bail IN number 2549 of 24. The London Council for the state 6 for an adjournment till next week to obtain the instruction relating to criminal antecedent, if any, against the petitioner, so also to produce the custody certificate. Put up this matter next week. Yes, next.
Item 14.
May I please? There are two appeals. Conviction under section 302 by 34 of the IPC.
Have you supplied the deposition copies?
Yes. Deposition.
Eyewitnesses are there.
Yes, ma'am. Prosecution has a two-fold matter. As per the prosecution case on 3/4/2021, the informant who is the PW5 along with man of PW2 and another person went to attend a marriage feast. And there was a quarrel with the appellant number in past appeal. And they returned. The appellants were returned.
How many years you are in custody?
Appeals, I am so that the appellant number 1 from the date of arrest. And that is on.
This occurrence took place in 2021.
21 custody.
You are.
And the second appeal, as there is no overtax has been attributed, and all the eyewitnesses have stated that appellant in first appeal he has given a stab blow to the deceased.
Yeah, just let us see. What is the name of the deceased?
Name of the deceased, madam.
Pratyusha Patra. Just a minute. Pratyusha Patra. Date of occurrence given? 3/4/2021. Who are the eyewitnesses?
PW5.
Yes.
6, 3, 12, 13, 19.
1, 2, 3, 5, 6, 12, 13, 19.
One be eyewitness.
1,
3.
1, 2, 3.
Acha, 2 be eyewitness. 1, 2, 3.
5, 6.
5, 6.
12, 13, 19.
12, 13, 19. Doctor is PW?
17.
17, man.
17 doctor. So let us come to any.
5, my lord. I want to press the statement of PW5 first. He is the informant. He was present from the beginning to end, my lord. PW5.
PW5.
I am the informant of this case. I know the accused persons of this case. I know the deceased Pratyusha Patra. The occurrence took place on 3/4/2021. I had gone to village Putkelchua to attend marriage of son of Bharat Bude. I, along with the Kabi Patra, Pramod Bude, gone to village Putkelchua to attend the marriage. At about 1 p.m., while I was sitting on motorcycle, Okrura BC came and abused me in filthy language. When Kabi Patra protested to it, he also abused him and assaulted him. Okrura BC, Sujit Majhi, Ajit Majhi assaulted Kabi Patra. When Pramod Bude protested, they assaulted him and he sustained bleeding injury on his head. We took Pramod Bude to Khoprakol Medical for treatment. Our family members came to village Utkelchua. Rukmani Majhi, Kushadhwaj Majhi, Kailash Majhi, Binodini Patra, Pratyusha Patra, Bhumisuta Bude came to village Putekchua. We were returned medical to village Putkelchua. We met them on the road. Okura BC, Ajit Majhi, Sujit Majhi, Dalimbo BC, Subidha Majhi, Rupendra Majhi assaulted all of us. Okura BC assaulted Pratyusha Patra by one knife on his thigh, belly and chest.
Okura BC ମାନେ criminal
appeal number first appeal.
First say one ଗୋଟିଏ ଜଣ appeal ଅଛି appeal ନା ଅଧିକା ଅଛନ୍ତି?
ସେଇ ଜଣେ second
1305 ରେ ଜଣେ appellant ଅକ୍ରୁର BC ଆଉ CRL 133 ରେ ନାଇଁ ସେ ବି ଜଣେ so ଇଏ ମାରଲା staff ବୁଲୋଟା କିଏ ଦେଲା?
ଅକ୍ରୁର BC
ଆଉ ଇଏ କଣ କଲା ଆରଟା ଯୋଉ କଣ ତା ନା
ସେଟା ଅଜିତ ମାଝୀ ନାରେ universal allegation against with
yes learning council for the state what is there against this Okrura? Petitioner this appellant in CRL 1305 he has dealt that blow by means of knife. So knife blow on the
chest and
thigh, belly and chest. Corresponding injuries were noticed by the doctor.
2 injuries by doctor. On one belly.
And he has stated also that it is possible by knife.
Possible by knife. Knife was seized from the house
so
of.
What about the other witness? That is
PW6 man.
No, Ajit Majhi. Ajit Majhi ର ରୋଲ ବିଷୟରେ ଯୋଉ ଆଇ ୱିଟନେସ୍ ଗୁଡାକ ଭିତରେ କିଛି କହୁଛନ୍ତି so far is in connection with the deceased is concerned.
Injured ମାନଙ୍କର medical examination ହେଇନି ଯୋଉମାନେ କହୁଛନ୍ତି ଯେ we have assault.
ନାଇଁ injured ଛାଡ ସେ injured ମାନେ କହିନାହାନ୍ତି କି ଇଏ disease କେମିତି ମାରଲା ତାକୁ କିଏ?
ସେ କହିଛନ୍ତି ଯେ ଅକୁର ବିସି
middle one matter.
ହଁ
Only Okura BC and Ajit Majhi dragged my son Pratyusha inside the house and both of them assaulted him by a knife on his chest and thigh.
But this is contrary to the evidence of other witnesses.
Except this witness, all the eyewitnesses have stated that Okura BC assaulted by means of a knife to the
PW2
PW2 in cross-examination at paragraph 5, he stated that I had not seen the accused persons assaulting Pratyusha by knife. So he is paragraph 5.
नहीं ये भी कहुची PW2 भी कहुची
but paragraph 5
assaulted by knife. Paragraph 5
I was injured at around 3:30 p.m. and Pratyusha was injured about 4:30 p.m. I had not seen the accused persons assaulting Pratyusha by knife.
Come to about this
3
my lord. PW3
last
paragraph
Okuru BC assaulted Pratyusha by knife on various body part.
ସମସ୍ତେ ସେଇ
अच्छा बाकी 12
6 ଆଜ୍ଞା
6 ବି ଗୋଟେ ହଁ
6 ବି କହୁଛି paragraph 2 ରେ at the last we went them Okura BC assaulted Pratyusha Patra by one knife on his thigh, belly and chest. Paragraph 2 last
lines. We met them Okura BC assaulted Pratyusha.
We met them Okura BC assaulted
ତାପରେ
by one knife.
12 ହଉଛି mother of the deceased. ସିଏ କହୁଛି paragraph 4 ରେ 4 ର third line. ଅକୁର ବିଷୟ assaulted
third line.
ଆଜ୍ଞା
Paragraph 4.
4 ଆଜ୍ଞା
4 ତା cross examination.
ଆଜ୍ଞା
Chief ରେ କିଛି କହିନି?
Paragraph 2 madam.
chief କହିଛି
କଣ କହୁଛି?
ଅକୁର ବିଷୟ third fourth line man fifth line.
When they protested,
ଅକୁର ବିଷୟ assaulted on the head of
Okurobishi assaulted on the head of Pramod Barik and the result of pulling injury. Also, my husband.
No, about the deceased ବିଷୟରେ କିଛି କହୁନି କା? ପ୍ରତ୍ୟୁଷ କିଏ ମାରଲା?
ପ୍ରମୋଦ କହିଦେଇଛି ବୋଧେ।
ଆଜ୍ଞା ସେଟା ଅକୁର କହୁଛି ଆଜ୍ଞା ସେ paragraph 2 ର last 3 ର just above.
Who is Pramod?
Paragraph 3 ର above.
Pramod ହେଇଛି, but it's Pratyush.
And Okura Bishi dragged my son and Okura assaulted by my son by one knife on his chest, belly and thigh. Paragraph 3 ର above tag.
That is the consistent version.
Consistent version that Okura assaulted by my son. Knife and in the FIR 8 named persons were there and charge was framed under section 149. But the investigation charge sheet submitted only against those two appellants and the investigation was kept open.
Number first line, when we are asking about the Okura Bishi, Ajit Maji, Upendra Maji, Narendra Maji came and Ajit Maji assaulted all of us and Okura Bishi dragged my son Pratyusha and Okura assaulted my son by one knife.
Insofar as Ajit is concerned, there is no specific text attributed.
ଦେଖନ୍ତୁ CRL number 1323 of 2024. He was on bail during that. The learned counsel for the petitioner submits that the petitioner was taken into judicial custody on 4/4/2021, but he was on bail during trial. And the evidence of the eyewitnesses would indicate that it was co-accused of Kurobishi who dealt knife blow on the thigh, belly and chest of the deceased Pratyusha Patro, as a result of which he died. And the allegation, the overtact of assault against the other co-accused persons, including the petitioner, are omnibus in nature. And therefore, the bail application may be favorably, and there is no chance of early hearing of the bail application, criminal appeal in the near future. Therefore, the bail application may be favorably considered. Stop. Learned counsel state, on the other hand, opposed the prayer for bail and submitted that PWs 1, 2, 3, 5, 6, 12, 13, and 19 are the eyewitnesses to the occurrence, and some of the eyewitnesses, like PW 1 and 2, have also stated that the petitioner also assaulted the deceased. He further submits that the doctor, bracket PW 17, who conducted postmortem examination over the dead body of Pratyusha Patro, has stated has noticed 2 star wounds on the epigastric region, left side, and in the upper abdomen, and opined that the cause of death was hypovolemic hemorrhagic shock due to stab injury of the heart and intestine. Considering the submission made by the learned counsel for the respective parties, the nature of contact attributed to the petitioner in the statements of eyewitnesses, the fact that he was on bail during trial, absence of any chance of early hearing, we are inclined to release the petitioner Ajit Maji on bail. October BC put up this matter after summer vacation.
Fine amount.
Fine amount must have paid earlier because there no such application is there. Which is your IA for stay of realization of fine? What is the number? IA number 3262. Acha. Any order has been passed? Disposal से order pass is on 20/12/2024 रे stay has been granted.
Yes.
बाकी कल की याद कर दो.
I will permitted to make a mention. Item 15. Though I have set a copies of the evidence, I permitted to take soft copies of the evidence.
No, pen drive दी. Yes, sir, pen drive जल्दा पड़े तो pen drive दे दो.